Today is July 30th, 2024. We will now begin the official hearing of this board, level 9 board review. We will be doing things a bit differently today, principally because we have a long delayed, highly contested matter that we're going to hear out of order. We will hear it first. Before we begin, I know there are a number of interpreters, sign language interpreters that the city has retained for purposes of this matter. So I'd like those individuals to state their names on the record so they may be sworn. Is there anyone present?
Hello, sir. This is your Cambodian interpreter speaking. My name is Nisai.
Okay,
N.
I was specifically relating to the sign language interpreters. So I need the sign language interpreters to make themselves known to the board so that we may swear you in. Okay, is there a sign language interpreter present? Mr. Wade, you may need to unmute if someone is, because everyone at the moment is muted. Do you have a sense of who those interpreters are?
I did not get the names, but I did get confirmation that they would be here from 12:30 to 2:30.
Okay.
We did have a sign language interpreter on the call just a few moments ago. Her name was Laura, but she seems to have dropped off the call. But she was aware that there is a case and she was present for it.
Okay. Given the nature of things,
She's coming in now.
okay, good. I just want to be certain that we don't want to put anything on the record before that sign language interpreter is present so that we can fairly capture everything. Okay. I appreciate everyone's patience as we get things started. Okay. Laura, you've identified as Laura Interpreter.
Yes.
Okay. Ma'am, I need you to raise your right hand so that you may be sworn. Do you swear or affirm that you will faithfully translate between English and American Sign Language and American Sign Language to English the proceedings in this matter, number HA 2024-000-025?
Yes.
Okay, thank you. Alrighty, then why don't we now get started? Interpreter, what I'd like you to do is everything that's said from this point forward, if you would interpret in American Sign Language. And we will continue to do that until we complete the matter at hand. Okay, thank you very much. Mr.
Chair,
Wade.
I'm sorry,
Yeah.
Mr. Chair. Could I please have the interpreter's last name?
Okay.
Cole, C-O-L-E.
Laura Cole.
C-O-L-E.
Okay, interpreter. All right, thank you very much. Okay. All right, thank you. Mr. Wade, would you read the matter in, please?
This is case number 56, hearing appeal ending 0025, 156 West Schoolhouse Lane, Penn Knox Neighborhood Association.
Okay, thank you very much. Who's representing the city?
Good afternoon, members of the board. Leonard F. Reuter, Senior Attorney for the City of Philadelphia.
Okay. Mr. Reuter, and just for the sake of procedural matters, how many witnesses will you have?
Well, we only have one witness who, Dr. John Farnham, who is here. We expect his testimony, if necessary at all, will be very brief.
Okay. All righty. Thank you. If need be, we'll swear him in if you called him. Okay. We do also have representatives of Penn Knox neighbors and the other appellants. So I'd like counsel for Penn Knox to put his name on the record, please.
Good afternoon, Mr. Chairman. My name is Neil Sklaroff. I'm a partner at Dilworth Paxson in Philadelphia, and I represent the Penn Knox Neighborhood Association.
Thank you very much. And we also have counsel for the other side, I guess, in order to keep things straight. Sir, would you put your name on the record?
Sure. My name is Matthew McClure, MCCLURE. I'm also here with Meredith Trego, Trego. We were the law firm of Ballard Spahr, and we are representing the Pennsylvania School for the Deaf.
Okay, thank you very much.
We are the appellee, i.e. the same side as the city.
Okay, thank you very much. Now, just in terms of, for the sake of this case, as well as everyone who's listening, I just want to again put on the record that this board is required by law to give deference to decisions that are made by the Historical Commission. So we will not be relitigating these Historical Commission hearings. The record has been created. We will defer to that record. Our purpose today is to determine whether or not the decision that was made in accordance with existing procedure, or if there was some inappropriate bias or a major mistake made. If that's essentially where we are today. And I want to also advise the sides that we will give each one approximately 15 minutes max to present your case. I don't know if you'll have witnesses. I can't imagine you should, unless there's a unique circumstance. So we ask you to be efficient as possible. And to, of course, because we are on Zoom, we need you to be patient. Let the other parties complete their thought and their statements before you jump in. We will hold everyone to that strict process of being patient with each other. So we aren't going to allow this thing to get crazy with a lot of over talking. That's not going to happen because we need to create a record that's appropriate. Mr. Rauder will be asked to begin, and after which Mr. Skleroff will be asked to present his position. And I guess, Mr. McClure, to the degree that you have something to contribute that's different than what Mr. Rauder is going to present, actually, you probably should come after Mr. Rauder in order to, if you need to say anything at all. I don't know if you need to say anything at all.
If I may, Mr. Chair.
Yeah.
This is not as you know, this is not a violation notice. This is an appeal of against L&I. I mean, appeal against the Historical Commission.
Right.
The burden of proof is on the appellants, and you know the tradition. At least when we've handled Historical Commission matters in front of Your Honor, in this board, it was always the appellants that go first because they're the ones who are arguing.
Okay, but in this, but Mr. McClure, just follow along, okay? Thank you. We're going to have Mr. Rauder go first, and then we will proceed from there. And we will potentially have questions from various board members. So I'd ask the board members just to be patient with us as we work through this, and you will have an opportunity to ask a question as
Chairperson Whitson, could we take a brief executive session?
Sure. Thank you. All right. Thank you very much. Let's do that. Take a very brief executive session. I don't see Mr. Wade.
The matter was read into the record, Chairman Woodson, but I can do it again if you like.
Yes, please do that. So for Mr. Kelly's benefit, if nothing else.
Yes, sir. This is matter number 56 on today's list, hearing appeal ending 0025 for the property 156 West Schoolhouse Lane. Penn Knox Neighborhood Association is the appellant.
Okay, thank you very much. Okay, after that brief out, we've determined that, in fact, I was incorrect. And Mr. Skleroff, thank you, Mr. McClure, and also I've been advised by counsel. So Mr. Skleroff will begin making his argument, and then we will hear from the city and potentially from Mrs. McClure. Okay, Mr. Skleroff.
Mr. Chairman, may I ask one question? I apologize.
Yes.
Just so we have it on the record, and also so we know, could we have a roll call of who the the board members are here today? Because we didn't get that. I just want to make sure we have.
Oh, sure, absolutely. We normally introduce ourselves. I skipped that step. So why don't we just start there? I'm Kenneth Woodson, board chairperson.
Roger S. Tennant, senior board member.
Beverly Penn, board member.
Penn Washington, board member.
Cortez Patton, board member.
Sherry, board counsel.
Board administrator.
Thank you very much. I think that's everyone. Okay, Mrs. Skleroff.
Thank you, Mr. Chairman, members of the board. Respectfully, Mr. Chairman, I may disagree with some of your general statements as we open this hearing. I hope you will give me the courtesy of hearing me out, and I'm sure you will.
Yes, as long as you're able to stay within the lines, we're okay.
Well, the members may recall that when we appeared on June 20th, after a long delay for the board's other important matters, we were instructed that our presentation today would be limited to 15 minutes in accordance with the rule of the board. Respectfully, we remind the board that the city charter, section 5-1005, establishes this board in order to provide a forum for citizens aggrieved by a city decision. This is our opportunity in this forum. The charter further provides that the board shall hear any evidence which the aggrieved party or the city may desire to offer. The annotation reminds us that the process must be orderly and in compliance with due process. We submit that the rule under which we appear today is contrary to the city charter. Further, this board is a local agency governed by the Pennsylvania Local Agency Law. Section 554 of the LAL provides that reasonable examination and cross-examination shall be permitted. If time were to permit, I don't think it will, I will make an offer of proof of the testimony of the 5 witnesses had prepared on June 20th. Let's talk about deference. Here, the commission based its decision on an incorrect interpretation of the preservation ordinance. As you will hear in detail, the applicant needed to try to market the property in good faith. It did not. The city may argue that the commission's interpretation of the preservation ordinance is entitled to strong deference. We will not try to anticipate the effect on state law of the Supreme Court's recent decision doing away with deference, but the board may only defer to the commission where the statute is ambiguous. There is no statute that says you must defer. That is a court-created concept. You may only defer in instances where there are 2 or more reasonable interpretations, and I need to emphasize reasonable. The whole point of any deference discussion is to explore and determine the intent of City Council. It is well settled that the rules of statutory construction apply to the Commission's regulations as well as the statutes. Following those rules, I will show that the board that the Commission's decision is very much contrary to the intent of City Council. It is not reasonable and it is not worthy of deference. Let's start with the facts. I'm going to try to share my screen if I would be permitted.
Yeah, please.
I think you have to let me in and then I can try this. Excuse me, I have severe carpal tunnel, which makes it difficult. I might even have this work.
You hit the green share screen button at the bottom.
I thought I did already.
You hit the share screen and then you have to pick which screen you want.
Yeah, that's where I was, I thought. And I picked this one.
Okay, it's
Do
loading.
you have
now.
that?
Yes.
This is, if you have that, this is a photograph of Boxwood.
Yes, we can see it.
That is the building on 156 West Schoolhouse Lane. I'm sorry, it's very difficult. And that is a photograph of the front of Boxwood as it fronts Schoolhouse Lane. Penn Knox appeals the December 8th decision of the Historical Commission to conditionally allow the demolition of Boxwood, again, the building at 156 West Schoolhouse Lane. Boxwood has a long history in the neighborhood, having been built in 1897 and most recently used as a group home. The Pennsylvania School for the Deaf occupies the former campus of Germantown Academy. The school acquired the campus in 1983. Boxwood, and if I can get to the next. Thank you for your patience. Boxwood is down here. Boxwood sits again on adjacent to the extreme southwest corner of the school property. In January of 2019, Penn Knox Neighborhood Association nominated Boxwood to become a recognized historic resource on the basis of 3 criteria and sought to place Boxwood on the Philadelphia Register of Historic Places. While the commission was considering Boxwood's nomination, and while the property was under the protection of the commission, the school purchased the property in July of 2019. Thereafter, by a 10-2 vote, the Historical Commission approved the nomination and added 3 additional criteria, any one of which would have been sufficient to place Boxwood on the register. Although the commission has the power to rescind Boxwood's individual listing on the register, it has not done so, and to my knowledge, has not been asked to do so. Accordingly, Boxwood remains an historic resource worthy of the full protection of the Preservation Code and the Commission's rules and regulations. Why? Because City Council said so. City Council declared that the preservation and protection of buildings of historic value are public necessities and are in the public interest. In fact, the clear purpose of the preservation ordinance as incorporated in the zoning code is to advance the preservation of historic resources, of which Boxwood is one. City Council took seriously the protection of a building like Boxwood. City Council made a clear statement that there would only be 2 circumstances that would justify the demolition of an historic resource like Boxwood. 1, a finding that demolition is necessary in the public interest, and 2, that there would be a showing that a building cannot be used for any purpose for which it is or can be reasonably adapted, otherwise known as financial hardship. Penn Knox brings this appeal to you because the commission's decision is based on a misreading of the rules and makes that in error, and the decision is otherwise not based on substantial evidence. City Council established a fundamental limitation on demolition. At 14-1005-6D, City Council ordained that no building permit shall be issued for the demolition of an historic building unless the issuance of the building permit is necessary in the public interest, or unless the Historical Commission finds that the building, structure, site, or object cannot be used for any purpose for which it is or may be reasonably adapted. In order to show that building, structure, site, or object cannot be used for any purpose for which it is or may be reasonably adapted, the owner must demonstrate that the sale of the property is impracticable, that the commercial rental will not provide a reasonable rate of return, and that other potential uses of the property are foreclosed. This 3-pronged standard is repeated throughout the regulations. In fact, in Regulation 9.4, City Council stated that the applicant has an affirmative obligation in good faith to attempt the sale of the property. We think that's pretty clear, unambiguous, and that City Council does not want to see demolition of an historic resource unless it has no value to anyone or any entity.
May I have a quick objection, if it's all right, just to make clarification? Mr. Sklarov said that City Council said that. I just want to make sure he clarifies whether that's the case, because that's factually not true.
Well, it's
Okay, wait. This is what we're going to do. Mr. Sklarov, listen to me. What we're going to do is that I will give each side liberties in terms of the opening statements. And I'd ask you to hold your objections till it's your opportunity to present, okay? So I will overrule that objection. Okay, Mr. Sklarov?
The school did not, may I continue?
Yes, please don't repeat. I've taken care of the objections. Please proceed forward.
Here, a fundamental and threshold question is whether the school attempted the sale of the property. Did it expose the property to the real estate market? The school did not and admitted it did not. Instead, the school abandoned the three-pronged test for financial hardship and claimed that it did not have the obligation to put the property up for sale because it is a nonprofit entity. Based on a novel interpretation of Rule 10, the school altered the hardship test from whether the building can be used for any purpose for which it is or may be reasonably adapted, and they changed that to whether the nonprofit institution itself can make reasonable reuse of the building for its own purposes. The commission relied on the school's interpretation of the code. In order for this board to defer to the commission's corporate interpretation, the board must try to identify the intent of city council in order to find that the commission's interpretation is reasonable enough to warrant deference. Fortunately, the board's inquiry is aided by the rules of statutory construction, which apply to the zoning code, and the commission's rules, including Rule 9 and 10. The General Assembly has established that the object of all interpretation and construction of statutes is to ascertain and effectuate the intention of the General Assembly, here, City Council. Every statute shall be construed, if possible, to give effect to all of its provisions. Well, here, the very first section of the Preservation Code states that the purposes of the preservation section is to preserve buildings, structures, sites, and objects that are important to the education, culture, traditions, and economic values of the city. Philadelphia Code 14-10055B and 6D established that the commission shall not approve a building permit for the demolition of an historic building based on financial hardship unless the three tests are met. These tests are repeated in Regulation 6.3, Regulation 9, and Regulation 10. The applicant has an affirmative obligation in good faith to attempt the sale of the property, to seek tenants for it, and to explore potential reuses of it. That's a quote from Regulation 9.4. The interpretation offered, we think that these are clear and straightforward implementations of the goals to preserve buildings and need to be given effect. The interpretation offered by the school nullifies these provisions, failing to give effect to the overriding need to preserve buildings. We often look to the structure of a rule to help understanding a rule's meaning. The school claims that Rule 10 supports this novel reading. Rule 10 first restates the three-pronged test that supports financial hardship. I'll repeat it again and again, but its sale isn't practical. We got to seek tenants. There are all no other useful purposes. Rule 10 then states that submission requirements may be found in 6.7, a lot of those. The rule then cites the additional submission and review requirements at Section 9. Only then does Rule 10 state that certain provisions of the code and the regulations may not have applicability to a property owned and used by a nonprofit. May not. Rule 10 does not say none of them, all of them, or which of them. We suggest it is not reasonable to read the three-part test in the beginning of Rule 10 and then assume that the city, in the same paragraph, the city council then gave all nonprofits a pass on those tests. In order to give effect to the many preservation protections in the code and the regulation, it makes no sense to do as the commissioners did, to broadly interpret Rule 10 to give free rein to nonprofits. So how do we give effect to all of the provisions in the preservation ordinance?
One moment. This is the interpreter.
Sure,
There
I'd be
should be
glad to
another
slow down.
interpreter, and we need to switch. Audrey do y'all see Audrey? Because I can't see her, and we need to switch.
No, I don't see another interpreter. Ma'am, are you going to be exiting for the whole day, or just need to take a break?
No, with this kind of case, it should have two interpreters, and it
Can you
says
hear me?
That's
Audrey.
all.
Oh, there she is.
Yeah, I've been here. I'm not sure. Can we have multi-pin options? Because then I can pin herself and and the deaf client so we can see everyone.
Oh, you
Maybe
should.
that's
Well, you should be able to do that on your screen, I believe, Mr. Wade.
I'm able to
gonna
pin
allow-
one.
I just hit allow to multi-pin. Did you get that? You got it? I'll give it to you, Miss Cole. You got it?
I'm looking.
You should be able to pin more than one person now.
I'm just looking for Audrey.
I can now. It should say ASL interpreter and then Audrey.
Okay, let's do this because we have limited time and want a limited amount of confusion. Audrey, would you put your last name on the screen, please? And then you need to be
Sure.
sworn.
Oh, there you are.
Yes, let me see.
Hey, Audrey, will you take over till 1:30 for 25
Absolutely.
minutes?
Mhm.
All right, thank you.
Absolutely.
Okay, now in the future, though, because this is we're making a formal record here, we will need to officially make the transition. So you just can't show up and start signing. We need to know who's signing. So, Ms. Rayna, would you raise your right hand so that you may be sworn?
Go ahead.
Do you swear or affirm that you will faithfully translate sign language from American Sign to English and English to American Sign, the proceedings in this matter regarding Penn Knox neighbors and the Historic Commission?
I do.
All right, thank you. Just one more before we start. Mr. Kelly, anything else do we need for the record? Yeah, I'm speaking.
No, Chair. No, we're
Okay.
fine.
Okay. All right, thank you. All right, Mr. Sclaroff, I apologize for that interruption, so please
No
continue.
need to do so. Thank you. So how do we give effect to all of the provisions of the zoning code? Well, the commission needed to determine whether a more narrow reading of the rule makes sense, and so it does. The logical view here is that some of the many filing requirements in the regulations in the code just don't apply to certain nonprofits because they are nonprofits. And paragraph 10 must be limited and not generally applied. In American law, we use a technique called the clear statement rule as a guideline for statutory construction. It holds that decision makers like the commission and this board should refrain from interpreting rules in a way that have consequences inconsistent with a statute unless the statute makes it unmistakably clear that it is City Council's intent to achieve that result. The demolition of an historic resource and Rule 10 is not that clear statement. Stated differently, if City Council wanted to exempt nonprofits from compliance with the obligation to offer the property to the market, it would have and could have and should have clearly so stated, but it did not. Our rules of statutory construction direct us to consider the consequences of a particular interpretation. What are those consequences? Well, to accept the commission's reading, the commission must accept that there are no distinctions among nonprofits, and any nonprofit is exempt from any and all restrictions. At the meetings below, the Preservation Alliance for Greater Philadelphia joined Penn Knox in opposing the school's application. Paul Stanke, executive director of the Preservation Alliance, testified that such waivers as promoted here will open the floodgates to the destruction of historic buildings that happen to be owned by nonprofits. The consequences here are severe, and the notion that every nonprofit can exploit its status to acquire and demolish an historic resource is contrary to the letter, spirit, and express purpose of the preservation ordinance, namely to preserve and protect historic buildings. The obligation to expose a property to the market is clear. It is not ambiguous. There is no room for a contrary interpretation. The zoning code provides a second class of cases that may warrant demolition, those that are necessary in the public interest. This is sometimes stated as a balancing of the public interest in building preservation and the public interest in whatever would occur if the demolition took place. It's fair to say that the school wants to demolish Boxwood for the purported reasons of student safety and improved delivery and enhancement of education, but put documents into the record that do not support its application and demonstrate all of its articulated goals can be met without demolishing the properties. The school presented a number of site plans, and what is on your screen now, I believe, is one of them presented in November of 2023. We do not know if there's a final plan because we believe the school has to obtain zoning variances. Therefore, this plan, and I think the others in the record, which is 1,200 pages, are not scaled and dimensioned plans as required by the code. The school wants to eliminate the areas of vehicular pedestrian conflicts shown here in orange, I believe, if it's come up that way, to enhance student safety. That's configuration has been there for more than 40 years. So they want to eliminate those, and they want to build a multi-purpose educational building at the end of the playing field. Again, we believe that both of these situations can be accommodated without demolishing Boxwood. We had prepared to offer the testimony of Janice Woodcock, an architect and planner who was a former executive director of the Philadelphia Planning Commission. Ms. Woodcock would have testified as she did below, that the removal of the pedestrian conflicts and the construction of the multi-purpose building do not require the demolition of Boxwood. Ms. Woodcock's opinions are bolstered by the site plan you see. There is no reason why you've got to demolish Boxwood in order to build that building or to remove the pedestrian vehicular conflicts. At the meetings below, we were told that there were a master plan, and I had trouble moving this. Please be patient. That there was a master plan, and from that there were three principal objectives of the master plan. One, to increase campus safety. Second, to increase sports opportunities. And third, to increase learning and mentoring opportunities, none of which call for the demolition of Boxwood and this is another of their a map showing the pedestrian conflicts and where they have buses parked there. You'll see, I think that's number 19, and they propose to put those bus parking over between the Early Education Center and the new building. So where's the beef? If none seek additional parking or the demolition of Boxwood, so where's the beef? We are told that the additional parking is needed for staff and visitor parent parking because the presence of parents enhances the development of these students. In defense of the school's application to demolish Boxwood, Mr. McClure argued it is critical to get hearing parents on campus so that they learn how to communicate with their deaf children, and that means parking and drive aisles. Providing convenient parking access to campus leads to better educational outcomes. So as we said, this calls for a balancing of parking spaces and the demolition of an historic resource. Here, the school needed to prove that meaningful additional parking can only be achieved by tearing down Boxwood. If this application was bought by a private developer, the commission and the board would be asking for a traffic study and a parking study to show the effects on the neighborhood. We really don't know from what we have so far whether they'll lose 35, 25, or 5, or none of the existing parking spaces. In any event, we suggest to you that a surface parking lot that disrupts a residential neighborhood's quality of life, for whatever reasons, should never be in the public interest. The regulations require that the commission look to neighborhood compatibility. I believe it's in Rule 6.9 that reads the compatibility of proposed work with the character of the historic district or with the character of the site, including the effect of the proposed work on the neighboring structures, the surroundings, and the streetscape.
Mr. Skleroff, just to interrupt a moment, given that we did have an interruption to change interpreters, I'm allowing you to go a bit longer than the stated 15 minutes, but I ask you to begin to bring this to a close so we can hear from the other parties.
I have about 3 sentences left. I tried
thank you.
My best to try to limit this.
And you're doing fine.
Well, I wasn't able to. We do know that demolition removes a residential building that within the neighborhood, in its place, a parking lot. The neighbors think that demolition will have a negative effect on their quality of life. The question was not considered, and at least not the subject of any finding of fact made by the commission. We suggest to you that the demolition is not in the public interest. We suggest to you there was no financial hardship proofs as required, and the board should reverse the commission. Thank you. I appreciate that. I don't think I have time to read into the record all of the offers of proof that I'm prepared to, but I'll just note for the record that we had 5 witnesses available on June 20th, and I dismissed them because I don't think 15 minutes would give them or the other parties time to sufficiently question and cross-examine them.
Thank you very
Mr.
much.
Chairman, thank you, board.
Thank you very much. Okay, we'll hear now from the city.
Thank you, Mr. Chairman. Again, Leonard Reuter for the City of Philadelphia. Rather than make a counter argument to Mr. Skleroff's presentation, I think we'll just start first by really kind of just preliminary type testimony from Dr. John Farnham.
Okay, Mr. Farnham, are you present?
Yes, I am.
Okay, I think we should, Mr. Skleroff, if you could stop sharing your screen.
I will do that.
There should be a button on the bottom there that says stop sharing.
Yeah, well, maybe I'll just close it. Did that work?
Yep, that worked. Okay.
Thank you.
Mr. Farnham?
Yes.
Thank you. Dr. Farnham, could you please state your name and spell it for the record?
I think I need to be sworn
Yeah,
in.
he hasn't been sworn yet. I need to swear.
Oh, I'm sorry.
Raise your right hand, sir. Do you swear or affirm the testimony you give today in this matter will be the truth so help you God?
I do.
All right, thank you. Place your hand down, Mr. Router.
Thank you, Dr. Farnham. Then could you then state your full name and spell it again for the record so it's clear?
Yes, my name is Jonathan Farnham, Farnham.
And do you work for the city?
Yes, I do.
And what position do you hold with the city?
I am the executive director of the Philadelphia Historical Commission.
And how many years you been doing that?
I've been the director almost 20 years, been with the commission about 22 years.
Okay, thank you. And prior to this hearing, did you compile a group of documents and other records relating to the Historical Commission's review of the permit application to demolish the property at 156 West Schoolhouse Lane?
Yes, I did.
Okay, I'm going to share my screen with the board's permission.
Yes, please.
Are these already in the record?
Actually, if Mr. Sklarov will stipulate to the accuracy, in other words, the accuracy and completeness of the record that we submitted previously to the board, I know Mr. McClure has already conceded to that. Then I don't need Dr. Farnham to certify the record. That's really was the main thing I was going to have him test. There's a couple other questions I have for him, but if Mr. Sklarov, if you're stipulating to the
stipulate that what you've submitted is the record that you have. We don't stipulate to its accuracy of the words included or the statements that were made. We just will stipulate that's what the record shows.
Mr. Rod, is that sufficient?
I think that's fine. Yes,
Okay.
we understand that you disagree with the
Well, we did
statements.
not have the opportunity to cross-examine witnesses at any point by the commission.
Okay,
or
Mr.
by the
Sklarov, we
board.
understood.
Right.
Let's
And
move on.
again, just so it's clear, the Historical Commission is not an adjudicative agency. They don't hold due process hearings on permit application reviews. That's what this board does, albeit in a deferential posture. And we'll address some of the legal arguments momentarily. But getting back then to Dr. Farnham. So Dr. Farnham then, so there was an application for the demolition of the building. I'll just call it Foxwood for short.
Yes, that is correct.
Okay. And was that discussed at multiple meetings of the Historical Commission and its subcommittees?
Yes, it was.
And how many meetings were held on that?
4 public meetings were held to review the application.
And so that would be the one meeting of the Architectural Committee?
Yes, that's correct.
And a meeting of the Committee on Financial Hardship?
2 meetings of that committee. Yes.
Okay. And would it be fair to say that that committee also, well, let me back up. There is no separate committee for reviewing applications in the public interest, is there?
No, the committee created solely for that purpose.
Okay. So the Committee on Financial Hardship and the full commission itself considered the public interest arguments?
Yes.
Okay. Do you have an estimate of how many hours the Historical Commission and its committees spent on the review of this application?
Yes, I did calculate that because it was somewhat unusual. The 2 committees, as well as the commission, held public meetings that lasted about 12.5 hours to review this application.
So that puts it on a par with previous reviews, such as the Turchie matter, the Dilworth House matter on 6th Street, or the Columbus statue case more recently.
Yes, this is one of the longer reviews of the Historical Commission during my tenure.
And at the time prior to that, the property had been designated historic. Is that right?
Yes, that is correct.
And at the time the nomination for designation was submitted, was the School for the Deaf the owner of the property?
Not at the excuse me, not at the time that the nomination was submitted. No.
Who submitted that nomination?
The Penn Knox Neighborhood Association.
So the appellants here today.
Yes.
Okay. And after the nomination had been presented to the commission, to the best of your knowledge, had the property changed hands?
Yes, the Pennsylvania School for the Deaf acquired the property while the nomination was under consideration.
Was that around 2019?
Yes.
Okay. And at that time, so that was before the commission had made a decision on whether or not to designate, is that right?
That is correct, yes.
Okay. And did the School for the Deaf ask the commission not to designate? That is, did they oppose the designation?
Yes, the school did oppose the designation.
Okay. And in fact, ultimately, the commission did designate the property, otherwise we wouldn't be here, right?
Yes, in March of 2021.
And are you aware that that designation is actually still on appeal at the Court of Common Pleas?
Yes, I believe that it is.
Okay. And in the meantime, then this application for demolition came to the commission, is that right?
Yes.
Okay. Now, with respect to the application that we're discussing today, did the commission staff review that first?
Yes.
And what was the staff's, did the staff make a recommendation about that?
Yes, the staff recommended that the Historical Commission approve the application.
Okay. And did any members of the staff ever visit the property or do a site visit or anything of the sort?
Yes, I visited the property along with one of my colleagues, Alex Till.
And did you assess the condition of the property?
Yes, we toured the property inside and out and also toured the remainder of the campus.
Okay. And did you, based upon your 20 some plus years as executive director of the commission and the experience of Alex Till, were you able to draw any conclusions about the condition of the property?
I would say the condition of the property was poor.
Okay. And did that visit help to inform the staff's recommendation?
Yes, it did.
Okay. Now, you said that the Committee on Financial Hardship had 2 meetings?
Yes.
Okay. And who sits on the Financial Hardship Committee?
5 members of the Historical Commission.
So that'd be the chair, the designee from Planning Commission, designee from the Department of Planning and Development, an architect and an architectural historian.
Yes, that is correct.
So-
in this case, the chair and the architectural historian are one and the same. So the committee was comprised of 4 members.
Okay. And that was Robert Thomas?
Yes.
Okay. Now, the standard, Mr. Sklarov discussed the standard, and you would agree with Mr. Sklarov that the standard is that a property can't be used for any purpose for which it is or may reasonably be adapted.
Yes, that is one of the 2 possible ways in which the Historical Commission can approve a demolition if it finds that that is the case.
Right. And another basis for allowing or approving a demolition would be if it's necessary in the public interest.
Yes, that is
Okay.
correct.
Now, there was some discussion about Rule 10 of the Commission's rules and regulations. What is Rule 10? If you could just briefly say what is the rule? I can share my screen also.
Excuse me. Rule 10 or Section 10 of the Historical Commission's rules and regulations provides process and procedures for reviewing financial hardship applications submitted by nonprofit organizations.
Okay. Can everybody see the screen?
Yes.
Okay, thank you. Now, Mr. Sklarov referenced this beginning of the rule at 10.1. Could you just read the second paragraph? Because I think that might not have been shared on the screen previously.
Yeah, so the second paragraph reads, the commission recognizes that the provisions of section 14-1000 of the Philadelphia Code and other sections of these rules and regulations may not all have applicability to a property owned and used by a nonprofit organization. No single set of measures can encompass the highly variegated types and contexts of buildings held by nonprofit organizations. The economics of a building in the middle of a college campus may differ from that of a church, hospital, museum, or child care center.
Now, there was some discussion again by Mr. Sklarov, and I think it was discussed at length below regarding the whether or not this rule or any other rule of the commission allows for effectively a waiver of the presumed requirement that a property owner put a property up for sale as part of their demonstration of financial hardship. Do you remember all that discussion earlier today and previously at the commission?
Yes, I do.
Okay. Now, with respect to a nonprofit property owner, does the commission require a nonprofit property owner to make an attempt to sell a property as part of the criteria for making a determination of financial hardship?
Uh, in previous practice, it has not required a nonprofit to attempt to sell a property that it holds.
So, and well, I'll address more in argument, in my argument. I don't need to ask you that next question.
I'm sorry to interrupt. The interpreters are going to switch.
Sure. Give them a sec.
Okay, which interpreter are we using now? You are muted, ma'am. Miss Cole, are you now the interpreter?
Yes, Laura Cole is the interpreter now.
All right, thank you. Please proceed.
Now, Dr. Farnham, in your experience, has the Committee on Financial Hardship and the Historical Commission itself exercised broad discretion on approving financial hardship applications?
Yes, it has.
Now, with respect to the Hardship Committee, did they hear testimony and evidence, if you will? Was there a presentation, that is, by the School for the Deaf regarding the financial difficulties that they were facing with respect to the Boxwood property?
Yes, there were presentations by multiple individuals that related to that.
Okay. And at the same time, both at the Committee on Financial Hardship and at the full commission, did members of the Penn Knox Neighborhood Association and their representatives also have an opportunity to rebut any of that presentation by the School for the Deaf on their financial hardship?
Yes, Mr. Sklarov represented the Neighborhood Association at the Historical Commission and Associated Advisory Committee meetings, and he did present witnesses to the Historical Commission.
Okay. And you
on the characterization of how we participate.
Mr. Sklarov, please, I didn't allow anyone to interrupt you.
Thank you.
And Dr. Farnham, then all of that presentation, the numbers, the figures, the things that were presented to the commission, those are part of the record that that the parties have stipulated to?
Yes, all of the materials submitted by the applicants, submitted by members of the public who participated, including Mr. Sklarov and his clients, and any other public comment, are all included within that record. Yes.
And the Committee on Financial Hardship ultimately made what recommendation to the full commission?
If I can read that recommendation.
Sure.
I'm sorry, I'm going to pull up.
Can you put it on screen?
Yeah, if you can put the exhibit on the screen. I'm sorry, I just don't have it memorized. It was fairly lengthy.
Let me see. It might take a second. All right. Can everybody see that?
Yes.
Okay.
Mr. Rod, I just ask you to be mindful of the time constraints.
Sure. Well, let me. Would it be fair to say that the Committee on Financial Hardship unanimously recommended that the financial hardship application be approved?
Yes, that is correct.
And then did the full commission ultimately adopt that recommendation?
Yes, the full commission ultimately did approve the application, and it added a couple of conditions on that approval.
Okay. What were those conditions?
That the commission review and approve a plan for the reorganization of the campus prior to demolition, that the building be documented to historic American Building Survey standards before it was demolished, and that archaeology be conducted to ensure that archaeological artifacts at the site were protected.
Now, there was also concurrently a request to approve the demolition because of the of its necessity in the public interest. Is that right?
Yes, that is correct. The application made both arguments that it was would impose a financial hardship and that the demolition was necessary in the public interest.
Was there any dispute or disagreement or objection to the general proposition that the Pennsylvania School for the Deaf, in fact, serves the public interest?
No, I believe that everyone who participated in the reviews conceded that the school provided a significant public service.
Okay. And during the course of the presentations that the school made to the committee and to the committees, the various committees, and to the full commission, did the school argue that the demolition of Boxwood was necessary for them in furtherance of the mission that they serve?
Yes.
Okay. And with respect to the specific need they had to demolish Boxwood, did they present documents and materials supporting their claim that it was necessary in order for them to essentially redesign portions of their campus to make it safer for their students and faculty and visitors?
Yes, they argued to make it safer and also to improve educational outcomes.
And was it, again, was much of that argument based upon the fact that the special needs of the students and faculty and staff, et cetera, that are present nearly every day on the campus, they might have heightened safety concerns than, say, persons who are not deaf or do not have other disabilities?
Yes, that was certainly part of the argument.
Okay. And did the commission, so the commission considered all of those arguments in that presentation as well?
Yes.
Okay. And then ultimately the commission, as you stated before, did approve the demolition of Boxwood with the conditions that you previously stated, right?
Yes.
Would it be fair to say that the commission accepted both the hardship argument and the public interest argument, but did not specify the degree of either of which, which of those arguments they were giving more weight to?
Yes, the commission concluded that both bases for demolition had been satisfied.
Okay. I have no further testimony I need to elicit from Dr. Farnham. I would like to make a very, very brief closing.
Well,
but
I think
I don't know if Mr. Sklaroff is going to cross on anything.
yeah, that's where I was headed. And also, each side will be invited to make closing at the end of direct testimony. Mr. Sklaroff, any cross-examination of Dr. Farnham?
Oh, yes, thank you for the opportunity to do so.
And Mr. Sklaroff, before you start, I'll just advise you again that we ask that you be very specific in terms of how he testified today and not to relitigate the hearing at the Historic Commission. Thank you.
Dr. Farnham, good afternoon. Were there any oaths taken that the witnesses that appeared at either the committee or the commission would tell the truth, the whole truth, and nothing but the truth?
The people appearing before the Historical Commission and its advisory committees, both the applicants and the public, no oath was given, nor has anyone ever been given in the 20-some years I've worked for the Historical Commission.
Was I given the opportunity to cross-examine witnesses that were supporting the Pennsylvania School for the Deaf's position?
I remember you asking many questions. I'm not an attorney, so I don't know what would qualify as cross-examination, but I do
If
remember participating.
If I might, the city will concede that the Historical Commission and its committees, as we stated before, do not hold due process hearings when reviewing a permit application because they do not make a final decision. There is no adjudication. Those are subject to an appeal to this board, which is why we're here.
Okay, understood. Mrs. Sclaroff?
Well, just one or two more. Do you recall the chairman of the commission advising me that I had no more time on several occasions and that we were not permitted to present witnesses unfettered by time limits?
I do not remember that, no.
And you have today acknowledged your agreement with substantive statements made by Mr. Reuter. Is that correct?
I have to object. That's to vagueness. I have no idea what the question is.
They were questions you were leading. And
which you did not object to.
Oh, wait. Mrs. Sclaroff, probably that question is not fair one for Mr. Farnham. It would have been more appropriate to object at the time the questions were placed. So if you would move on, sir.
I did at the committee meetings. That's all I have.
Okay, thank you very much.
Great service of the city.
Thank you. Now, in this instance, Mr. Reuter, I'm not sure, Mr. McClure, I want to be fair to everyone. You have any cross-examination, Mr. Farnham?
I just have a couple of clarifications. I didn't get a chance to do any questions myself, but I just have a few questions, if it's okay.
Yes. Again, I'd ask you to be very specific and very pointed in your cross based on his testimony. Thank you.
Dr. Farnham, you've seen many contested demolition matters in the past, correct?
Yes.
In the level of participation of opposition being permitted by the commission, 1 being the smallest amount, 10 being the highest amount, how much did the commission allow Mr. Sclaroff and his clients to participate?
It's my memory of the reviews at the Committee on Financial Hardship and at the Historical Commission that Mr. Sclaroff and his clients were liberally provided with time to present their case. Very, very long presentations, much longer than typical Historical Commission reviews.
Did the Historical Commission receive reports over the objection of School for Deaf that they were obtained by a trespass on their property, and did they allow that testimony?
Objection leading.
Okay, Mr. McClure, would you restate that? And that, I don't believe that matter came up earlier. And so again,
the issue of the level of the, well, I'm glad I asked my own questions of Dr. Farnham, but the issue of the level, the amount of participation of
okay, just restate your question, please.
Did Mr. Sclaroff's clients report present a report?
Yes.
Was it reviewed extensively by the commission?
Yes. A report by architect Janice Woodcock.
Was the Pennsylvania School for the Deaf architects and staff asked to come back at a second hearing and address some of the issues in that report?
Yes, the Committee on Financial Hardship did ask the school to provide additional information and to respond to claims made in that report. Yes.
Gotcha. Isn't it true at the time of the sale, the nomination of the property was being proposed to be sold to a developer for a project?
It's my understanding through some zoning applications that yes, at the time the property was nominated, a private developer was considering an apartment project for the site.
And I know Mr. Reuter asked you whether the staff made a recommendation. I don't think he asked you what the staff recommendation was. What was the staff recommendation?
The staff recommended approval, recommended that the application demonstrated that it was financially that there would impose a financial hardship if the building were compelled to be retained, and that the demolition of the building was necessary in the public interest.
Can you briefly explain the logic of the necessary and public interest recommendation by the staff? I think it's staff.
Well, try to be brief. It's fairly complicated. The school essentially argued that it needed to reorganize its campus and move parking lots and driveways from the center of the campus for a couple of reasons. One, to provide for safe passage for the students between the various buildings on campus so that they didn't need to cross moving traffic or move around parked vehicles. And two, that the school needed to also move the parking lots and driveways to allow for the construction of a new building that would link an early childhood center on Coulter Street to the main buildings on the campus on Schoolhouse Lane. And that the only way to do that and to improve not only safety, but the educational outcomes for the students was to demolish this building and shift the parking and drive and fire lanes onto the property where this building is located.
Was there testimony regarding the need for additional parking?
Well, there was an argument that parking was needed, especially for parents of students, with the claim that that young students at the school, their parents needed to participate in the educational process because otherwise young deaf students would be language deprived, and that could have serious implications for their education across their lifetime. So there's an argument that they needed to bring parents of students onto the campus easily to encourage them to participate in their child's education and to learn American Sign Language themselves so that they could communicate with their children. And if they were able to provide easy access to the campus for the parents, that educational outcomes would be significantly improved.
And the testimony of the testimony related to that argument, was that given by Melissa Dragonette Hawk, who's the headmaster?
Yes.
Objection. All we're doing is repeating what's in the record. It's not any findings of fact of the.
Okay, understood. Mr. McClure, I'm asking you to move on. You indicated that you...
I have one other question. Two other questions. Dr. Farnham, is there anything related to the necessary and public interest prong that requires anyone to attempt to sell a property?
No.
No cases that ever provided that?
Necessary in the public interest, I'm unaware of a case in which the commission or the court later found that the sale of the property or an attempt to sell was required.
And Dr. Farnham, you've been the rulings in this case, both under Rule 9 or alternatively Rule 10 for financial hardship, as well as the necessary and public interest. Is there anything about the commission's decision here that strikes you as clearly erroneous when it comes to prior precedent and rulings of the commission?
Objection.
What's the objection? Pardon me?
I have to object. It's a conclusion. He doesn't know. Can't be understood to know.
Okay.
He's asking a conclusion on an issue of law.
Okay.
Go ahead.
Okay. Mr. McClure, also, you will be given an opportunity to make a final argument. Okay.
I understand. I just real quick, I may rephrase it. Dr. Farnham, is there anything about this decision based upon not your legal expertise, but your experience for decades being the head of the Historical Commission that says that this decision was inconsistent with prior decisions of the commission or the rules, regs, or ordinance of the Philadelphia Historical Commission?
Objection.
So noted. Please answer, Mr. Farnham.
I would say that this decision is entirely consistent with other financial hardship and necessary in the public interest decisions.
Okay.
Thank you.
Thank you. All right, thank you very much. We will move to hear final argument from all parties. Um, Before we do that, I need to take a short recess with the board for executive session. We will be back momentarily. Thank you. Ask, Mr. Router, as well as Mr. McClure, to give the argument in that order. And then, of course, Mr. Skleroff, you can have the closing word. We'd ask, of course, that you gentlemen be mindful of the time. We're looking at approximately 2 minutes per in terms of your closing. Thank you. Mr. Router?
Thank you very much. I think the issue here is partly one of deference, but also just common sense in terms of the fact that the application sought approval for the demolition of Boxwood either because it's necessary in the public interest or because of financial hardship. And there is some overlap between those two arguments, obviously. You'll see reading through the over 1,000 pages of documentation that was developed over the course of this matter at the Historical Commission and its committees, that there was an enormous amount of information that was provided, not just by the applicant, but also by the objectors, by Penn Knox, and by persons that they brought in, both from materials from Janice Woodcock, statements that were made by Paul Steinke of the Preservation Alliance. And there, with respect to the hardship application, I just want to focus a little bit on the question of Rule 10 and the alleged requirement that a property be sold. The case law, which I will say some of the cases were not reported, but generally speaking, the case law that has been reported has shown, and previous applications have shown, that there is no specific requirement to sell a property. The issue of selling a property in a hardship case, and this goes towards pretty much any hardship, including a zoning hardship in a zoning context, it goes to the reasonability, whether or not a property can be used for its permitted purpose, or in the case of a historic property, whether it can be maintained as a historic property, or whether it can be reasonably adapted to a use that's financially viable. So typically, it's assumed that somebody would try to sell a property to see, and because it's the market that decides whether or not there's an adaptive reuse for the property. But that's not we don't require nonprofits particularly. We don't require anybody to try to sell a property, but we specifically don't have specific allowances, and we don't require nonprofits to sell property because, and the courts have also upheld the concept that the determination of whether a property can be reasonably adapted is directed towards the actual owner of the property, or in this case, the nonprofit owner. Can the nonprofit owner reasonably adapt the property? The nonprofit owner isn't required to put it up for sale for a third party to take over the property. So consider, for instance, like, let's say you have a campus. This happens to be on the edge of the School for the Deaf's campus, but suppose this building were in the middle of the campus. It would be absurd to require the school to put up a property in the middle of their campus for sale to a third party. The question is whether or not the school itself can adaptively reuse the building. So I wouldn't be fooled by the fact that this property happens to be on the edge of the campus. It's pretty clear that they don't need to be forced to sell the property, which in effect could, and this is where it's sort of, there's some overlap with the public interest exception, because there is a need for them to use that land where Boxwood is to further their mission. And again, with respect to the public interest thing, I think Mr. Skleroff was actually correct that there is a balancing test there, which is you balance the interest in preservation against the public interest. And the commission looked at all the materials that were presented, understood the special needs of the School for the Deaf's students, faculty, staff, and made a determination that improving the safety of the students, as well as improving the potential academic outcomes and quality of life for their students and faculty, for their community, far outweighed the benefits to the public in preserving Boxwood. So on that basis, we believe that the commission's decision was clearly correct. And certainly, even if you don't agree that it was absolutely the only outcome, it certainly was not clearly erroneous, and this board must make a determination that the commission's decision was clearly erroneous given the preservation ordinance and their own rules and regulations. Thank you.
Thank you very much.
Yeah.
Mr. McClare?
Chairman, members of the board, I'm going to start off with just a little bit of a background on the School for the Deaf very quickly. I want to address Mr. Sklerov's procedural issue, and then I'll wrap up on the merits.
Again, I'll be monitoring your time, sir.
School for the Deaf has been around for 200 years. Its students are overwhelmingly diverse, overwhelmingly below the poverty level, and more than 40% of them have more than one attribute that requires care, i.e. they're deaf, they're hard of hearing, or they have some other additional ailment. They are deaf plus, so to speak. It's public, their mission is in the public interest. Regarding Mr. Sklerov's procedural claim that somehow he's being deprived of hearing, whatever deprivation that is his own making. Mr. Sklerov wrote this board 3 separate times to saying that he's happy to do this hearing on a briefs and argument instead of having a new record. If Mr. Sklerov was fine with doing briefs, that means he didn't need cross-examination or direct examination. He's agreed that the record is sufficient. So after waiting 6 months of this, now he's bringing up this issue that he's being deprived due process. The board has bent over backwards into scheduling this matter for Mr. Sklerov. I will tell you, shockingly, we weren't even served a copy of this appeal when it was filed, even though we're across the street from the main protagonist in the appeal, Erwin Traus, who owns an apartment building and lives across the street, who is actually driving this appeal for the Penn Knox neighbors. But a little bit on the merits. The record's huge, but there's really one critical read throughout, and I'm sure when the board was reviewing for today, if you read the minutes from the Historical Commission itself, you had the staff recommendation who said the building 156 Schoolhouse Lane is of relatively minor architectural importance. I don't think anyone heard the word boxword until it was actually made up by the author of the nomination, Penn Knox. The significant need of PSD was recognized. The weighing of the interest was recognized. The condition of the building was testified to, and the importance of the other buildings on the campus that are being taken care of by the School for the Deaf. That's all noted in the recommendation of the staff. And then if you look into the testimony and a discussion from Dan McCubry, who's the chair of the Architectural Committee. He was on the full commission, as well as he's on the Financial Heart Committee, and he's a noted architect with the firm of Venturi Scott Brown. He talked about that there was no reuse for the school. He also said, well, we did look at reuses for other uses. We looked at residential. It didn't make any sense because he talked about having to have a single traffic lane, and that would conflict with the porte cogere, and the amount of improvements that had to be made to the building was just absolutely obvious. And there's extensive testimony and analysis in page 698 and 699 of the minutes, and as well as if you watch the video. He also talked about parking. And he said that with the building being removed, there's a 37% increase in parking. And obviously there's a pedagogical need for that that was corroborated by the testimony of Melissa Dragonet Hawk in ASL. Right now, there's only 117 spaces on campus. When they remove the dangerous parking lots, the ones where the kids can get killed, we're down to 69. If we take the building away, and we can reconstruct it. I mean, we can take the building away and we can put parking in that area. We're up to 134 spaces. That's a dramatic increase between the two. The best that we could do with keeping the building, is 98 spaces. Again, it's a 37% increase. Then if you look to Dr. Thomas's comments, he talks about the importance of looking at the entire school, that the school is a historic asset. Yes, there's 4 buildings from the 18th century there the school takes care of. The school also is a historical need itself and provides incredible public interest. And that was explained by Dr. Thomas. And he only came to that opinion again after 12 and a half hours of testimony, an examination of everything. He talked about the expert testimony they received on deaf space and the needs that the deaf community has when it comes to designing a building and operating a building is different. Yes, they need more parking. Why do they need parking? Because most parents of deaf kids aren't deaf. So that means if they're coming from a poor means, they need to get on campus as quickly as possible and as often as possible so they can learn ASL, so their child can learn ASL. So I don't know, so they can communicate to their children. So if this is not an important public need, I don't know what is. And concepts of, why don't you do remote parking or crossing guards are really insensitive to the needs of the deaf community and really they really just are just inappropriate. The other thing he talked about the historic importance of having a healthy school and what a financial drag this building would be on the school, and that was stated over and over again during the testimony of both Dr. Thomas and Dan McCoubrey. So this was a relatively complex matter for the commission. It's a relatively simple matter in my mind, in our mind for this board. This was reviewed for 12 and a half hours, extensive testimony, extempore expert views. No witnesses were not allowed to testify. No one was not allowed to testify, and they testified extensively. Reports were handed up. And then the other thing I'd like to say very briefly, because we did have an ADA claim that was in underlying our application, that is the Americans with Disabilities Act. The term discrimination under statute doesn't just mean the vernacular, like when someone is discriminating against someone else. Under the Americans with Disabilities Act, which is a federal law, you have an affirmative obligation to make reasonable accommodations to allow for an equal playing field between folks who are disabled and folks who are not disabled. We use the term disabled because it's the term in the statute, but not because it is appropriate. And they looked at this and they said, given the four buildings, the constraints, the safety needs, the amount of historic fabric they already take care of, and the relatively unimportance of this building, 156 Schoolhouse Lane, aka Boxwood, they did not think that they did not warrant denial of the application and thought we met our burden.
Okay. Mr. McClure, I would ask if you could bring things to a close, please.
Very quickly. So I will say the following. Not once was there any attempt on behalf of the appellants to understand the needs of the school for the deaf. Rather, there was...
He has no
Sir, Mr. Skleroff, this is not time for argument. Okay?
Yeah.
Rather, we were met with a fairly paternalistic, we know better, you should follow us. The School for the Deaf has been around 200 years. No one knows how to educate deaf children better than the School for the Deaf.
Okay, thank you, Mr. McClure.
Maybe just make finish for a second, Your Honor.
I'm asking you to bring it to a close, please.
Okay. The commission got it. They listened for 12 and a half hours. They applied their law. They made no mistake, and they gave everyone the opportunity to be heard. Thank you.
Thank you very much. Mr. Skleroff.
Thank you, Mr. Chairman. What you've heard from Mr. Reuter and Mr. McClure is the presentation, as they would characterize, of a lot of testimony that they put forward. I could go piece by piece. The reason that we require a property to be put up for sale is a check on whether that historic resource has any value, not just to the owner, but to anyone. And that's why it is couched like it is in several sections of the ordinance. Now, the hearing, you can read, if you wish to, all of the minutes, and you'll see the disproportionate amount of time, but that doesn't matter. You've heard Mr. McClure highlight the very highlights of a very long testimony that he produced at several committee meetings, some of which he told me was his meeting, not mine. I couldn't talk. In any event, let's talk about things that might touch your hearts. There is no doubt that the Pennsylvania School for the Deaf does great things. I won't try to characterize them. I once was an educator, but I don't know anything about this. And so I'll leave that everything he said about what the school is great, and we have no reason to doubt it. Mr. McClure said this is a violation of the Americans with Disability Act. Well, the city of Philadelphia has a form to file for reasonable accommodation. That was not done here, nor was this claim pursued at the commission. The question here is much a question of legal interpretation. That is the interpretation that Mr. McClure suggested, which is the question is not whether the building can be reasonably reused for any purpose by any person, but whether a nonprofit institution can make reasonable reuse of the building for its purpose. Nowhere in the code, nowhere in the regulations is that test put forward. And so we need that extra test. As for the public interest arguments, it is a balancing. But the testimony of Janice Woodcock below was that they can do all of the great purposes they want without removing and demolishing boxwood. I showed you some plans that came from the school's presentation. And one of them was concept site plan, retain 156. That's the building Boxwood, 156 West Schoolhouse Lane. And in the upper right-hand corner of that, it says total parking 137 spaces that they can achieve without demolishing boxwood. They want to show us another plan with only 69 or talk about 170. Well, that's fine, but they can get parking. The question is, why can't they put the parking in? And it's only the parking we're talking about, not talking about building the building, not talking about eliminating the conflicts, but we're talking about getting parking. And that's what the public interest argument is all about. As to the economic hardship, I have shown you, and it hasn't been rebutted, that in order for you to defer to that decision, first of all, it needed to be more of a due process decision. But putting that aside, it's your decision that's going to be reviewed on an error of law. And it's your decision that needs to be based on what the arguments we have put here before you. I agreed that to do this on briefs because there's so much in the record, and we have great testimony in the record. And I was willing to do that because I didn't think that 12 hours of your time was a good use of our time or the school's time. I thank you very much. Mr. Chairman, thank you for the extra time. Again, I would have put offers of evidence, but I cited some of that material, but we had a developer who said the property would be attractive.
Okay, Mr. Sklar, thank you very much.
Thank you, Mr. Chairman.
Thank you. And I appreciate your patience and everyone's participation. The board will review the testimony and the record that's created today and will announce its decision at the August 27th hearing. You're invited back to hear the decision of the board at that time. We will not make a decision today. Thank you very much for your patience. If you have any questions regarding the process, please contact Mr. Wade or Mr. McSherry, counsel to the board. Thank you very much. Have a good day. And we have a long list of matters. There are people who have been very patient, so we need to begin calling the other cases. The interpreters, thank you very much. You excuse. Have a good day.
Thank you.
Okay, let us jump right in if we can. Mr. Wade, Well, no, my apologies. I need to hear from the law department. I assume that there's a list of cases that you will want to announce that have been resolved, or the matter is not ripe for today. So I'd like to, who's going to present those cases on behalf of the law department?
Good afternoon, members of the board. Jim Kelly on behalf of the city.
Mr. Kelly, good afternoon. What do you have for us today?
Starting with number 2022-2205, 241 East Girard Avenue, Daniel Angrianto, move complied.
Move complied. Just one moment, sir, before you proceed. I need to check in with Mr. McSherry. Mr. McSherry, do we need to have a conference on some of those matters before we hear from the law department?
We do not. If there's any issues, I will bring them to the board's attention.
All right, thank you very much. Okay, Mr. Kelly, please proceed.
Thank you. Number 2023-1495, 817 South St. Bernard Street, Jermaine Harris. That's an agreement for a city affirm with a 120-day stay of enforcement.
City affirm 120 days. Thank you.
Number 2023-2093, 7384-90 State Road, Michael Rossetti. That was withdrawn by the appellant this morning.
Okay. Oh, before you go further, Mr. Kelly, I just want to remind everyone who's listening and waiting to hear, if your name or your address is announced and it's announced as moot or moot complied, that means your matter is resolved for today. You can leave. If you need information as to how, what the difference, the subtle difference between moot and moot complied, please call the office. There's a number on the communications you've received. So we ask you to do that. And again, it goes without saying, this is a formal hearing. So please present yourself that way. No sleeping, no eating, no drinking, no reclining in your easy chair or your bed. This is a formal hearing. Thank you very much. Mr. Kelly.
Thank you. Next is number 6, 2023-2316, 2613 West Hunting Park Avenue, Ilya Rabovetsky, moot complied.
Thank you very much.
Number 9, 2023-2389, 3328 North 17th Street, Delancey Holdings LLC, moot complied.
Thank you.
Number 10, 2023-3419, 1440 Hellerman Street, Enelido Valentine, agreement for a city affirm with a $150 fine.
City firm 155. Okay, thank you.
Number 11, 2023-3421, 1422 West Hunting Park Avenue, Sylvia McFarland, moot.
Thank you.
Number 12, 2023-3425, 1422 West Hunting Park Avenue, Sylvia McFarland, moot.
Moot. Thank you.
Number 13, 2023-3438, 3021 Vare Avenue, Ibrahim Shaji. That's a joint continuance request.
Is this the first request?
Yes, it is.
Okay. Noted as continued.
Thank you. Number 16, 2023-3455, 4650 Large Street, Linda Chepris, moot.
Thank you.
Number 17, 2023-3458, 6135 Reedland Street, Nia Tate, moot.
Moot. Thank you.
Number 18, 2023-3459, 1154 Mercy Street, Ming Lee, moot complied.
Thank you.
Number 20, 2023-3480, 4219 Market Street, John Naclario. That's an agreement for a city affirm with a $150 fine.
Thank you.
Number 22, 2023-3488, 706 North 5th Street, Gerardo Somoza, Gabriela Somoza, agreement for a city affirm with a 90-day stay of enforcement.
90-day stay. Okay. Thank you.
Number 23, 2023-3493, 2644 North 33rd Street, Abir Mena, moot.
Moot. Thank you.
Number 24, 2023-3494, 3091 Tulip Street, Taka Worm LLC, moot.
Moot. Thank you.
Number 25, 2023-3495, 2424 North Fifth Street, Charlene Anderson, moot complied.
Thank you.
Number 26, 2023-3496, 2424 North Fifth Street, Charlene Anderson, moot.
Moot. Thank you.
Number 27, 2023-3599, 6027 Kings Essing Avenue, Mohammed Tahir. That's an agreement for a city affirm with a $150 fine.
Okay. Thank you.
Number 31, 2023-3739, 5128 Saul Street, Wen Ting Chen, moot complied.
Thank you.
Number 33, 2023-003, 742, 1250 East Palmer Street, Elizabeth Cunningham and Avinash Puryarvaram. That's an agreement for a city affirm and a $200 fine.
$200 fine. Okay. Thank you.
Number 34, 2023-3744, 1250 East Palmer Street, Elizabeth Cunningham and Avinash Puryarvaram, moot.
Moot. Okay. Thank
Number
you.
35, 2023-3746, 1250 East Palmer Street, Elizabeth Cunningham and Avinash Puryarvaram. That's an agreement for a city affirm and a $200 fine.
$200 fine. Thank you.
Number 36, 2023-3747, 1250 East Palmer Street, Elizabeth Cunningham and Avinash Puryarvaram, moot.
Thank you.
Number 37, 2023-3750, 2043 East Auburn Street, Ruslan Niken, moot complied.
Moot complied. Thank you.
Number 38, 2023-3751, 2048 East Auburn Street, Ruslan Niken, moot complied.
Moot complied.
Number 39, 2023-3755, 4793 Silverwood Street. I'm just going to spell it AMALACHUKWU. Last name NDUBUISI, moot complied.
Moot complied. Thank you.
Number 40, 2023-3766, 711 West Montgomery Avenue, Christina Osborne. That's an agreement for a city affirm and a $300 fine.
$300. Okay.
Number 41, 2023-3767, 711 West Montgomery Avenue, Christina Osborne, moot.
Moot. Thank you.
Number 41, 2023-3771, 714 East Chelton Avenue.
Sorry, that's number 42.
42, yes. Number 42, ending in 3771, 714 East Shelton Avenue, Carla Pagan. That's an agreement for a city affirm and a $150 fine.
Okay, thank you.
Number 43, 2023-3772, 1811 Berks Street, OMSAI Group 02 LLC. That's an agreement for a city affirm and a 60-day stay of enforcement.
City affirm 60-day state. Okay, thank you.
Number 44, 2023-3774, 528 to 540 West Oxford Street, Norbor Kolobi, moot complied.
Moot complied. Thank you.
Number 46, 2023-3785, 5943 Malta Street, Tawana Ross, moot complied.
Moot complied. Thank you.
Number 47, 2023-3792, 4719 Hartle Avenue, Alba Barona, moot complied.
Thank you.
Can we have the Spanish interpreter read that and then dismiss the Spanish interpreter?
Oh, perfectly. My apologies. Who is the Spanish interpreter?
This is the interpreter speaking. I'm on the line. My
Sir,
name is
yeah.
Stephen.
Stephen, what is your last name, please?
My name is Aubain, Aubain.
Okay, raise your right hand so that you may be sworn. Do you swear or affirm that you will faithfully translate from Spanish to English and English to Spanish proceedings today?
Yes, I do.
Okay, sir. What I'd like you to do, given the fact that this matter is being resolved now, from this point forward, I'd like you to interpret the English that's spoken translate into Spanish, please.
Yes, sir.
And we will indicate when not. Mr. Wade, is this the only in Spanish interpreted case for today?
His only case. I do not see the appellant in the waiting room.
Okay, all right, thank you. Let's proceed.
Or in the hearing. I'm sorry.
Yeah. Let's proceed. Mr. Kelly?
Can we just read that one again?
Yeah, read it again and just allow for the interpreter. Just let him respond, okay?
2023-3792.
Así que, go ahead.
4719 Hartle Avenue.
Y para el caso 2023-3792-4719 Hartley Avenida.
Alba Barona, moot complied.
Y Alba Barona. Y este caso es discutible cumpliendo.
Okay. Thank you very much, sir. I think that concludes our need for interpretation. Thank you.
Thank you very much.
Okay. All right, Mr. Kelly.
Number 49, 2023-3799, 801 East Chelton Avenue, Jerome Henry, moot complied.
Thank you.
Number 50, 2023-3803, 4613 Liper Street, Stephen Humphrey, moot complied.
Moot complied, thank you.
Number 51, 2023-3805, 2842 Hope Street, Anthony Fuentes. That's an agreement for a city affirm and a $150 fine.
Thank you.
And finally, number 55, 2023-3918, 1103 East Cheltenham Avenue, James Rush, moot complied.
Thank you.
That's all that I have. I do believe my colleagues have some additional matters, though.
Mr. Chair, before you call the colleagues, I just want to confirm between 40 and 41, I believe Ms. Skiles is the attorney of record. I just want to make sure that the agreement, one was marked moot and one has a city affirm with agreement. I don't know if they were read into the record.
I think I made a mistake on the one that I had sent over. The agreement is for number 40, 41 is moot.
Okay.
Okay. All right, thank you. As per our standard procedure, we'd like you to use the raise hand sign, and I will call on you in order. Mr. Leonard Router. You're muted, Mr. Router.
Thank you. Just a couple more and I apologize to some of the appellants here. As you probably saw, I was tied up for a couple of these that came in at the last minute. For number 4, HA 2023-002101, 782 to 84 South 3rd Street. The appellant is Nate Ross. This is regarding a streetery license that is still under review. So we would like to continue this for 90 days. We think that will be sufficient to resolve all of the matters.
Okay, so noted. You'll be continued.
And also, I do want to correct, and this was my fault. I provided inaccurate information to Mr. Kelly on number 6, HA 2023-002316, 2613 West Hunting Park Ave. The appellant is Ilya Ravetsky. In this matter, it is all of the violations are moot complied except for 2. This is by agreement, which we can provide to the board later. But all the violations will be marked moot complied except for 2 violations, one for not having a certificate of occupancy and for not having a special assembly occupancy license that goes to one of the units at the property. The rest of the matter will be marked moot complied by agreement. This is one of these multi-unit properties that has several different commercial tenants.
Okay, so are you prepared to proceed today?
Well, no, we have that by agreement with their attorney of the property owner, Mr. Barsky. So we'll provide a copy of that agreement as soon as we're
Okay.
done. I'm done here
S- s-
today.
So that the record is clear, the outstanding violations that are not moot complied, is there an existing agreement as to how those are to be resolved?
They're just going to be marked city affirmed.
So that's the agreement between the parties.
Yes. Yes, and just so the board understands, the tenant was also issued violation notices. And again, the tenant is specifically responsible for not having the CO for their unit. It's an event space and not having a special assembly occupancy license. They did not appeal those violations, so the city, so again, those will be affirmed, and then the city will move for enforcement on that unit. But the rest of the violations, which were more building wide or complex wide, those have been all corrected.
Okay.
We'll put it in the agreement.
Okay, so there is an agreement regarding the outstanding violations and the decision the city affirmed.
Correct.
Okay, all right, thank you. All right, let's move on.
Yes,
Anything else?
Yes, number 28, HA 2023-003600, that's 1511 South Street. Matthew Levinson, doing business as Dinner and Movie. This is a case where the city is going to be asking for a continuance. This is a little bit of a more complicated matter involving basically street furniture. There's a pre-existing license that predates the streetery by some years, and we're just still trying to work out how that works in relation to, pardon me, in relation to the particular street furniture that's being used at this location. And again, I apologize, I didn't have an opportunity to make the request earlier, but based on information that I received just earlier today before the hearing started.
Okay.
I don't know if the appellant is present.
Let's ask, is anyone present? Is Matthew Levinson or someone representing Dinner and Movie? Anyone present? No one's responding?
We'll still go with the continuance because
Okay,
we may
how
wind up,
long?
we may wind up,
Mr. Wade, did you have something for us?
How long is this going to need?
Mr. Rowder?
if we have how long to continue the matter?
Yes, yes.
I think 30 days. We just need to have some discussion with the streets department about this one.
Okay, all right. We'll notice continue for at least 30 days.
Thank you very much.
Okay. Anything else?
Yes, just one more. Number 30, HA 2023-003645, 3904 Coral Street. I don't know if you want to wait to call this. There's just really one question we have for the appellant that could resolve the entire matter, because we may withdraw the violation, but I just.
Okay, I'd like to get through these preliminaries, then we can call it in order and we'll get to it quickly.
Okay, that's fine. All right,
I'm pressing.
Yeah, we'll have to get to this later then. I'm sorry.
We'll
Ms.
call
Meyer.
you.
I'm pressing for 3904.
Okay, ma'am.
Coral Street.
Ma'am,
Yes, sir.
we're gonna call you later. We aren't
Yes,
prepared to
sir.
hear the case just yet, okay?
So
if
you guys, you
listen,
call me?
ma'am, just we will call the case in order. So if you could remute yourself, we aren't prepared to hear it just yet. We're trying to do preliminary matters now, okay? Thank you. Just be patient with us. Okay.
And number 48, HA 2023-003794, 1355 North Front Street, Mohair and Partners LLC. That is continued by mutual agreement of the parties.
Okay. That's continued. Thank you.
And I think that's it for me.
Okay, thank you.
Thank you.
All righty. Ms. Kristen Pasha.
Good afternoon, Chairman Woodson and members of the board.
Afternoon.
I have number 14 and 15 on the list, which pertains to 6233 Chelwyn Avenue. I did send the board a request yesterday asking for a continuance for the city. My inspectors are unavailable.
Okay, both matters, both 14 and 15?
That's correct, Chairman Woodson.
Okay, I need the last four digits for both of those.
The last four are for number 14, 3440, and for 15, 3442.
Okay. And just give us an address and the name of the appellant.
The appellant is Prince Dennis, and the address is 6233 Chelwyn Avenue.
Thank you very much. We note both of those matters as continued.
And
Thank you.
Chairman Woodson, in the record, just reflect, I'm not sure that the appellant signed on to the call. He may have received my continuance request yesterday. I did CC him, but
Okay, we'll just call Prince Dennis. Anyone else related who's here on behalf of 6233 Shelburne Avenue? Prince Dennis. No one is responding. But in this miss, given that you are not prepared to go forward, we will note it as continue.
thank you.
Anything else?
No, that's it for me, Chairman Woodson.
Okay, thank you. Ms. Jalen Johnson.
Good afternoon, board. My name is Jalen Johnson. On behalf of the city, I'm here for number 29 on the list, which is 2023-003-603 in regards to 2218 South 66th Street. The appellant is Adisha Kita, and there's an agreement for city affirm with a $250 fine.
$250 fine. Okay, thank you. So noted. Anything else?
That is all I have. Thank you.
Okay, thank you. Okay. Let's see here. That appears to be all that we have from the law department. So, Mr. Wade, why don't we go back and start with the matter that Mr. Router raised?
I have a question.
Yes, sir.
On number 20, 00346080, 4219 Market Street. It was a city affirm with $150 fine.
Correct. That's the agreement that they reached with the appellant.
But also knows that number 21 is the same address and the same appellant.
Yes. I don't recall who.
Make sure I didn't miss something.
Sure. Who's representing that matter? This is.
Members of the board, this is Jim Kelly on behalf of the city. I'm representing the city for number 20. That case has an agreement for a city affirm with a $150 fine. Case number 21 is assigned to my colleague Glenn Reuter. There is no agreement as of yet on that case.
Okay.
It's just an agreement on the first one.
Okay, thank you.
Thank you.
Ready? Okay, what we're going to do. Yes?
I'm sorry if I'm the one speaking. I am attorney. I don't even remember I was called on the list unless I miss anything. May I just
Well,
mention?
who is your client?
My client is called the Metro Real Estate Investment. I do have the MI number.
What's the address? What is the
One-
address?
Number 7.
1022 South 57th Street.
Yes, that case was not called. As far as I determined, we're going to proceed with the hearing today in order.
Okay.
Okay. All right. Thank you. So let's go back, Mr. Wade. I think Mr. Rotter had a matter he thought could be quickly disposed of. Mr. Rotter?
He had to step away. I was trying to put Miss Molina in a breakout room, Mr. Reuter. When he gets back, I will communicate with Miss Molina to try and get her in a breakout room. But
Okay.
the first matter listed has a Cambodian interpreter.
Okay, well, let's do that then.
This is case number 5, hearing appeal ending 2309, 5211 Filbert Street. Richard? No.
Jeffrey Cohen for the city of Philadelphia.
Okay, and who's the Cambodian interpreter?
Hello. Quick one. They have an attorney, Scott Seagum. He's getting ready to jump on.
Okay, I need to have the Cambodian interpreter to present himself to the board or herself.
I think she did make herself, she did mention that she was here before. Ms. Nisei, I think.
God,
I don't know if she's still here.
Oh, yeah. Okay, we can't proceed until we identify the interpreter. Mr. Wade, do you know if the interpreter is still available to us?
The interpreter was present. I do not see them, but I can reach out to see if I can have them rejoin.
Okay, in
Yes,
the
please.
meantime, is there another matter we can call while we're trying to track down the interpreter?
We can call number 7.
Okay, let's do that.
Case number 7, hearing appeal ending 2322. 1022 South 57th Street, Metro Real Estate Investment LLC.
Okay, that's Miss Eleanor Chen, who's representing the city.
Good afternoon, Amy Skiles on behalf of the City of Philadelphia.
Good afternoon, Miss
Scott
Skiles.
Sigmund here on behalf of 5211 Filbert Street.
Okay, we are not, that matter is not the matter we're dealing with now.
I'm sorry. I'm sorry about
please-
that.
Yeah, please mute yourself, sir.
I'm sorry.
Okay, and I believe Miss Eleanor Chen is representing the appellant in this matter.
Yes,
Ma'am, would you put your name on the record, please?
Eleanor Chen on behalf of property owner, Metro Real Estate Investment LLC.
Okay, thank you. Ms. Skiles, do you have witnesses today?
Yes, I will call Inspector Michael Herbert.
Okay.
May I
No,
interrupt?
ma'am.
I'm sorry.
No, you interrupted me while I was in the
Okay,
middle of
I'm
giving
sorry.
instructions.
Okay.
Okay, Ms. Skiles, is your inspector available to be sworn?
Yes, I know he was on the call. Inspector Herbert? I see him. Inspector Herbert, can you hear me?
Yes, I can hear you.
Okay, great.
Okay, Inspector Herbert, we'll need to swear you in.
Yes, sir.
We'll need to see your image as well, sir. So if you turn your camera on.
Here we go.
Okay, please raise your right hand so that you may be sworn. Do you swear or affirm the testimony that you give today be true to help you God?
I do.
All right, thank you. Before we proceed, Miss Chen, you had something you needed to ask? You had a question you need to ask before we get started?
I don't think I ever contact any of law department attorney yet because I simply don't know who's assigned to this matter.
Well, let's do this. Miss Skiles, would there be any benefit from you having a breakout discussion with Miss Chen?
Sure, I'm happy to do that.
Okay, Miss
Okay.
Chen, we're going to
Yep.
put you in the breakout room with Miss Amy Skiles.
Thank you.
We will move on to the next matter.
Ms. Skiles, do you need your inspector?
If you could, yes, please.
And it was Herbert?
Yes.
Okay, just please pay note the prompts you will get, Miss Chen, and you will be put in the breakout room. Okay, Mr. Wade, should we call someone else?
Case number 8, hearing appeal ending 2374, 3254 North 6th Street, Chantel French, doing business as Caring for Kids Learning Center.
Okay.
Jeffrey Cohen on behalf of the City of Philadelphia. Good afternoon.
Okay. Ready? Mr. Cohen, do you have any witnesses today?
Well, let's first check whether the appellant has shown up. I couldn't find
Okay.
her in the participants list. She was told at the last hearing that because the owner of the property is French Connection LLC, or French Jones Connection LLC, that the LLC needs an attorney.
Right.
So is there any attorney here for French Jones Connection LLC?
Or is Miss Chantel French available? Anyone available for that address, 3254 North 6th Street? Okay, no one is responding.
Let me check service.
Okay.
I'd also add for the record, while Mr. Wade is checking, that on July 23rd, emailed an updated version of the city's exhibits packet to Ms. French at an address that she had previously responded to me from.
Okay, thank you.
This matter was previously continued for counsel. Ms. French listed 1224 South 18th Street as her mailing address. Notices hearing was sent to 1224 South 18th Street on both April 3rd for a May 21st hearing. The same address was mailed this notice of hearing on June 20th for today's hearing.
Thank you very much. Mr. Cohen, no one has responded. What is your preference?
The city respectfully requests a city affirmed for non-appearance.
Okay, Mr. Tennant, what time do you have? You muted, sir.
2:44 p.m., sir.
2:44 p.m. Alrighty, thank you very much. We will poll the board with regard to HA-2023-002374 3254 North 6th Street. Appellant Chantel French, doing business as Caring for Kids Learning Center. City affirm non-appearance.
City affirm non-appearance.
City affirm for non-appearance.
City affirm non-appearance.
City affirm non-appearance.
Thank you very much.
Thank you, members of
right.
the board.
Thank
I
you.
would also note that Mr. Scott Sigmund from case number 5 is here. That's the case with the Cambodian interpreter. I don't know if the Cambodian interpreter is here.
Yeah, that's what we're attempting. We can't proceed until we find that interpreter.
Thank you.
We're trying to contact the interpreter's office. Would a breakout room be helpful for that matter or no?
Possibly. If Mr. Sigmund is on board, I guess we can
I'm
talk
on
a
board.
little.
I'm on board with whatever
Yeah.
you like to do.
Okay. We're going to put you two in the breakout room. Mr. Sigmund, I just advise you to pull over if you're driving.
Thank you.
Okay, that brings us to number 19,
Okay.
hearing appeal ending 3470 5.5 River Road.
Okay. Who's representing the city? Who's representing the city in regard to 5.5 River Road?
That may be Amy. She's in a breakout room.
Okay. If that's the case, then we need to move on to our next matter.
I don't know if Len is available on the call. Len, are you here?
It appears that he's still in the breakout room. So let's move down then to number 32.
I believe that's Amy as well.
Okay.
I'm sorry, that's Len.
That's Lynn. Okay.
I'll try and find the next matter. Okay, case number 45,
Okay.
hearing appeal ending 3784 4048 Higby. Ahmad Halik.
Who's
I'm
representing
Daniel
the city?
Flores. Yes, I'm Daniel Flores. I'm representing the city of Philadelphia.
Okay. Good afternoon, Mr. Flores. Welcome to the board.
Thank you.
Okay. You have a witness today, Mr. Flores?
Yes, we do. Mr. Jason Alexander.
Mr. Alexander, if you would make yourself known to the board so that you may be sworn.
Hey.
Turn on your camera, Mr. Alexander.
It's not working on.
Okay, Mr. Alexander, we can barely see that glare in the back. If you could reposition.
Let me see.
If you can, that's okay. Please, but let's get this preliminary out of the way while we're doing that. Raise your right hand so that you may be sworn, sir. Do you swear or affirm the testimony you give today be the truth so help you God?
I do.
Okay, the appellant is Ahmad Halik. Mr. Halik, are you present? Ahmad Halik. No one is responding. Mr. Flores, no one is responding. What is your preference?
We request that grant a city affirm for non-appearance.
Okay, Mr. Wade, you check service, please. Okay, Mr. Wade, is you
Just give me 1 second.
okay?
Notice of this hearing was sent to 4453 Sansom Street. I just want to confirm that that is his address. The address he has listed looks like 4453 Sansom Street, but it's not the most legible writing, so let me see if I can just check.
Okay.
Mailing on the address, the mailing on the on his inactive rental license is a completely different address, but
Okay, let's do this then. Given the nature of the questions regarding service, I think we need to continue this matter so we can sort that out. Okay, Mr. Flores?
Yes.
Yeah, we need to resolve this issue of service because he may have not received served notice of today's hearing.
Understand.
So the record should reflect that this matter has been continued for lack of service. Ready? Okay, Mr. Wade, what's the next likely opportunity?
You're going to excuse Mr. Alexander also.
Yes, Mr. Alexander, you excuse, given that we aren't going to hear this case today.
Okay, thank you.
Yeah.
case number 52, 53, and 54 are all the same address, but different attorneys for the city are handling.
Okay, so
Case
let's start with 52 then.
Case 52, hearing appeal ending 3806, 1525 Dickinson Street. Jacqueline Weirin.
Okay.
Yes.
Who's representing the city? Okay, who's representing the city on 1525 Dickinson Street?
Jeffrey Cohen.
Okay, this is number 52, 3806. If Mr. Cohen is that attorney, then he's probably still in the breakout room. Let's move on to number 53. Okay.
My list has Miss Carmody for this matter. It has Amy for the following matter and Jeff for the final matter.
Okay, so Miss Carmody is 52.
Good afternoon, board. Originally, it was scheduled to be handled by the 3 separate attorneys. However, Mr. Cohen is going to be handling all 3 today.
Oh, yes?
Yes.
Okay. And so Mr. Cohen is in the breakout room, I believe.
I believe so.
Yes, okay. All righty.
Len, are you back?
I'm back.
Okay.
We're
All right,
gonna
let's.
have the next matter for Len, case 19, hearing appeal ending 3470, 5.5 River Road. Carl Newber.
Okay, Mr. Router, you have a witness for that case?
Yes, just if you just give me a moment, please. I believe it would, well, the inspector would be Natasha Lee, but I believe she's out. So Anthony Williams will be handling this.
Anthony Williams, are you present?
Yes.
Please unmute, raise your right hand so you may be sworn. Do you swear or affirm the testimony that you give today be the truth so help you God?
Yes.
Okay, thank you very much. Okay, Mr. Router and the appellant, Carl Newber. Mr. Newber, are you present? Carl Newber. Mr. Wade, do we see Mr. Newber in the on the screen anywhere?
I do not see anyone under that name. Mr. Newber listed 5.5 River Road, Philadelphia, Pennsylvania, 19128 as his address. Notices of this hearing was sent to 5.5 River Road, 19128 on June 20th, 2024.
Okay. Mr. Router, no one is responding. What is your preference?
The city would ask that the matter be marked a city affirmed for failure to appear.
Okay. Mr. Tennant, what time do you have?
2:53 p.m.
2:53 p.m. Okay. We will poll the board rather than HA-2023-003470, 5.5 River Road, Carl Newber, city affirmed non-appearance.
City affirmed for non-appearance.
City affirmed for non-appearance.
City affirmed, non-appearance.
City affirmed non-appearance.
Thank you very much. That resolves that matter. Mr. Router, there was a matter that you felt could be resolved rather quickly. Which number was that?
That would have been, let's see,
30.
Coral Street, number 30.
Number 30, let's call that matter.
Case 30, hearing appeal ending 3645, 3904 Carl Street. Neredia Molina.
Okay. Neredia Molina, are you present? Miss Molina.
She is here, was.
Is she still in the breakout room? No, she's not.
Okay, Mr. Router, did you come to the resolution of this matter with Miss Molina?
Unfortunately, no. There was, I was in the breakout room. She had some difficulty getting in, and then I had
I'm
to step
here.
away. Oh, there she is.
Yes, it just got on mute.
Okay, ma'am, give us your name, please.
Narrator Molina.
Okay, would you raise your right hand so that you may be sworn? Do you swear or affirm the testimony you give today be the truth to help you God?
Yes, sir.
Okay, thank you. You
I
can
do.
place your name down. You can place your hand down. Mr. Wade, can we change the name on the screen so we know, keep track of her,
Doing it
please?
now.
Thank you. All right, Mr. Rodder, please proceed.
Thank you. I actually just have one question for Ms. Molina. Ms. Molina, are you the property owner of 3904 Coral Street?
Yes, sir.
Okay, and you hired a contractor to work on the property, is that right?
American Watering.
Okay, and do you remember the name of the specific name of the person who you were in contact with? Was it a Shanton Punter?
Oh, I do not remember his name
Okay.
because they're different people that I spoke to.
Okay. So, members of the board, the issue here is that this is a violation it's a violation of a plumbing permit for doing work on a curb trap. The property that was associated with the curb trap is Ms. Molina's at 3904. She hired the plumber. We believe that this violation was issued in error to Ms. Molina. This type of violation should only be issued to the actual plumber who did the work and whose name is on the permit. So we are going to withdraw this violation as to Ms. Molina, and we will continue against the plumber.
Okay,
So
thank
we can mark this appeal violation withdrawn.
Okay, we'll note this violation withdrawn. Ms. Molina, you are excused. This matter is resolved.
Thank you, sir.
You're
Have
welcome.
a good day.
Okay.
Thank you.
You're welcome. Okay. All righty. Okay, Mr.
Any
Wade,
questions?
is the waiting room empty or
There's an
breakout
agreement.
rooms empty?
Ms. Skiles has come to an agreement on one of her matters.
Okay, let's call her then.
Case number 7, hearing appeal ending 2322. 1022 South 57th Street, Metro Real Estate Investment LLC.
Okay, Ms. Amy Skiles.
Yes, good afternoon again. I was able to speak with Ms. Chen in the breakout room, and we've come to an agreement for this matter for a city affirm with a 60-day stay of enforcement.
City affirm 60-day stay. Okay, Ms. Chen, would you put on the record confirm that agreement?
Yes, I do.
Okay, thank you very much. That matter has been it's been resolved based on the agreement between the parties. Thank you very much.
Thank you.
Ms.
Thank
Chen, have a
you.
good afternoon. Okay.
You too. Bye-bye.
All right. Okay.
Brings
Mr. Wade, I'm not sure where we go next.
That brings us to case 21, hearing appeal ending 3481, 4219 Market Street, John Liero.
Okay, who's representing the city?
Thank you. May it please the board, Leonard F. Reuter, City of Philadelphia.
Okay, Mr. Reuter, you have witness for today?
I do have Inspector Brett McDonald.
Okay, is he present?
I believe so.
Okay, but let's check to see if the appellants are present before we swear anyone else in. Is there anyone regarding 4219 Market Street present? John Neclario. Anyone present? No one is responding. Mr. Wade, do we see that individual?
I do not see anyone under that name.
Okay, please check for service, please.
Nagliero listed 5136 North Carlisle Street as his address. Notice of this hearing, as well as the case above, case 20. Notice of both hearings were sent to 5136 North Carlisle Street on June 20th, 2024.
Okay. All right, thank you. What's your preference, Mr. Ryder?
I do want to note, I think I should note for the record that as Mr. Wade just pointed out, number 20 is also 4219 Market Street, also appealed by Mr. Nagliero. That matter was resolved by an agreement with Attorney Jim Kelly so there had been contact. I had not had contact with Mr. Nagliero, but did indicate when providing our exhibits that this case was still going forward. I think it was clear that there were two separate appeals and that the resolution of one appeal did not resolve the other. They were actually somewhat different violations, not really directly related to each other. So it's the city's position that he knew that this other appeal was still going forward, and we would ask that the matter be marked city affirmed for failing to appear today.
Okay, thank you. Mr. Tennant, what time do we have?
3:00 p.m., sir.
3 p.m. We will poll the board regarding HA 2023-003-481, 4219 Market Street. John Nagliero, NACLERIO, city affirmed non-appearance.
City affirmed for non-appearance.
City affirmed for non-appearance.
City affirmed non-appearance.
City affirmed non-appearance.
Thank you very much. Your witnesses are excused, Mr. Rutter. Thank you.
Thank you.
Mr. Chair, may I be excused?
Yes, actually.
Can we take a break?
Yeah. Given we've had a long day so far, so we need to go off the record until it's 3 o'clock. I'm going to go off the record to 3:05. Okay.
Okay.
Case number 5, hearing appeal ending 2309, 5211 Filbert Street, Richard.
Okay, we have a Cambodian interpreter. The Cambodian.
I'm the attorney for Scott Sigmund.
Good afternoon, sir. We didn't get your name.
Scott Sigmund on behalf of the 5211 Filbert, and we do not need the Cambodian interpreter.
Jeffrey Cohen on behalf of the city. We have actually two things that we didn't have at the last hearing. One, Mr. Sigmund represents the appellant. He is an attorney and he speaks fluent English. And two, Mr. Naw, the appellant, I do not believe will be testifying and thus does not need translation.
Well, except that he needs to be aware of what's the proceedings themselves. That's the other purpose of the interpreter. So, in fact, the appellant can hear in his native language the proceedings.
Well, I don't believe he is actually here today because he is represented by Mr. Sigmund.
Is Sigmund, is that your appellant is not here today?
I don't believe he's on the line. I have our property manager, Mr. Savage, on the line.
Okay.
But I don't need any testimony. This would be pretty much the factual part of this case. The counsel and I will do by stipulation, and we just have argument.
Okay, Mr. Sigmund, but one thing I will say to you, though, you need to pull over. Otherwise, we can't proceed.
No problem. I'm in a parking garage. I'll be parking right now, and I will pull over.
All right. Mr. Cohen, you have any witnesses?
No, the stipulation that Mr. Sigmund was referring to, we can put on the record now and then proceed directly to legal argument.
Okay. Okay.
Essentially, the conditions in violation.
Can we dismiss the interpreter?
Yes.
I have no objection. Yes.
No objection.
Cambodian interpreter. Hello.
If he appears, then let him know we don't need him.
I see him. I just.
Okay, Mr. Cohen.
So the stipulation the parties are proposing to the board is that the conditions in violation exist, that there is an unlawful club that is operating at 5211 Filbert Street. It's the city's understanding that this club is operated by not directly by the tenant, but by someone the tenant had allowed to operate at the property unbeknownst to and without the consent of the owner. So there is actually an ejectment action in court that the owner has filed against the tenant and against the unlawful operator of this club.
That is accurate.
I would also point out to the board that there was a Blir appeal filed by the unlawful club operator, Curtis Boswell Jr. That Blir appeal was number HA 2023-003529. And on August 23rd of last year, Blir issued a notice of decision that late hearing was denied. It was an untimely appeal, and the board had already denied that for being untimely.
Okay. And so I guess we want to hear legal argument in that matter, or do you want to wait till Mr. Sigmund has something to put on the record?
Oh, well, let's let Mr. Sigmund put what he likes on the record.
Mr. Sigmund?
I would put on the record that stipulation by and between counsel.
Okay.
Okay.
So I guess I'd like to ask a question, Mr. Cohen. So the issue of the violation itself is still valid. And the issue is who should have been written to? Or do we have the wrong person, or should have been written to someone else?
Well, I actually do have a brief presentation on responsibility for violations under the code. I would also add, just for the board's sake, that there isn't really a way that the city can come up with an agreement with Mr. Sigmund and the owner of the property, because any potential stay of enforcement would impede the city's ability to enforce the cease of this unlawful club.
And there's a cease in place now?
There has been since, I think, April of 2023.
Okay. Okay. Anything else you want to put in the record?
Yes, if I could just share my screen.
Sorry.
Oh, sorry. If I could share my
about the record.
Oh, sorry.
I was just saying that the cease has been in place, and this illegal tenant continues to violate it routinely. I just want to put that on the record.
Okay. All right.
And with that, I'd like to share on my screen some of the city's exhibits packet, but very few pieces of it. Let's jump to page 20.
Mr. Cohen, do you need a witness for this?
No, these are clips of the Philadelphia Code.
Okay.
So it's entirely a legal argument. I've highlighted the relevant portions from section A105, which is Philadelphia Code Administrative Code, section A105.1, that an owner is responsible for their property, the testing, maintenance, and repair of structures and systems, and that under A105.4, if there's any contract, such as a lease between an owner and an occupant, that assigns the occupant some responsibility for fixing these violations, it still doesn't relieve the owner of direct responsibility under the code. It basically provides the owner with a way of either indemnifying themselves or of passing some responsibility onto the tenant, so that they're both held responsible and not only the tenant is held responsible. This is also similarly in the fire code. There's a similar provision of owner-occupant responsibility. Correction and abatement of fire code violations is the responsibility of the owner, and if the occupant creates them, they can also not in lieu of, or instead of, it is also be held responsible in addition to the owner for those violations. And then there is here also under the administrative code, for applications for permits, the owner would need to sign off on an application for a permit. If an application is made for a person other than the owner, it shall be accompanied by a signed statement that the qualified applicant has the owner's authorization. And basically that's because if, for instance, the tenant wants to change the use of the property from some commercial or office use into a club, they would need to do so with the owner's permission. And if the owner hasn't given permission, it's unlikely that application would be filed, let alone granted. And with that, I'll stop sharing my screen.
Okay. All right. Thank you.
Chairman, may I just interrupt? I do apologize. I'm just not clear from either Mr. Cohen or Mr. Sigmund. Is Richard No the owner of the property?
Yes.
Yes. Richard Naw is the owner of the property. And I think I mentioned Curtis Boswell Jr. had previously applied to or appealed to this board. He is the operator of the club in question.
Okay.
And not our tenant. Not, he's a squatter.
Okay, thank you.
Okay. Mr. Sigmund, is there anything you would add that would help the board come to a decision?
Yes, if you look at the code that was cited, the one thing, whether it's fire code or city code, there is no contract. That's the whole problem here. This is a squatter. We're not in landlord-tenant court. We're in ejectment in Philadelphia Court of Common Pleas because we don't have a contract with this Boswell guy who's running an illegal club. And the problem is, I don't know what responsibility a landlord could have when the city of Philadelphia ordered to cease operations under the law that this guy can't operate. And to this day, he still operates. He just operated a few days ago, a legal club over the weekend. So he's violating the law of the city of Philadelphia. I don't know what more the landlord can do other than go to court against him because he's a squatter. And we're doing our best to get rid of this guy. And that's the problem here. There is no contract. This is a squatter. We want the city to get rid of him. We want the courts to get rid of him, and we're fighting to get rid of him. So there has to be some level of equity here when there is no contract and there is no obligation other than the landlord going to court, and that this squatter has a CSOPs against him and continues to operate in literally in spite of every rule and law in the city of Philadelphia.
Mr. Sigmund, one thing I just need clarity on, how and when did this individual take control of this property?
He took control of this property through some kind of connection with the tenant. The tenant stopped paying rent and basically turned it over to the squatter, unbeknownst to my client, the landlord. And my client has been doing everything he can to get rid of these people. The city issued CSOPs. He retained my
you said that
services
already. I just want to be clear on something. Now, your client in this instance, what kind of property is this?
It's like I would call it maybe like a commercial style warehouse style building, garage style warehouse building.
Okay, and was the owner aware that the tenant had moved?
The owner was only aware they stopped paying rent. He went out and had no idea what was going on. He had no access to the property, unfortunately. The locks were changed unbeknownst to my client's knowledge.
Okay. All right. Okay. Mr. Cohen, I assume this matter was posted as cease operations?
Yes, as of April of 2023.
Has there been any additional enforcement action by the police department?
The police and L&I have occasionally returned to the property to, again, enforce the cease, and in certain cases, the violations of the liquor law that the current occupant is engaging in. Unfortunately, this is one of those weird cases where this board's jurisdiction, which is determining whether the violations exist and who is responsible for those violations, is fairly clear cut, but the enforcement of those violations is not. Because as Mr. Sigmund pointed out, his client is trying to eject this current unlawful occupant. And the L&I does want to work with his client and make that ejectment happen, because obviously the cease alone is insufficient to stop this activity. That said, it would actually, counterintuitively, it would hinder the city's enforcement efforts if there were some sort of non-city affirmed or even stay of enforcement determination, because that would keep the city from enforcing the cease that both parties want to enforce, or both parties present today want to enforce. The unlawful occupant clearly does not and did not want that enforced, which is why he filed a separate appeal.
Okay, thank you. Any additional questions from the board? Okay. Is it any final argument from the parties?
No, Your Honor.
No, thank you very much. I would like to point out, just really for Mr. Sigmund and Mr. Naw's sake, that the city is willing to work with you to stop this unlawful behavior, this unlawful nuisance activity, so we can continue talking after the board has rendered its determination.
Please.
Okay, thank you very much.
Please reach out to me at your convenience. Thank you.
Okay.
Thank you.
We will pull the board regarding HA-2023-00.
Mr. Chair, excuse me. Can we take a brief?
Let me read this in and then we'll take a
Thank
brief,
you.
okay? Regarding HA 2023-002309 5211 Filbert Street. Richard, no, we're gonna before we actually vote, we will take a brief executive session.
Thank you.
Now be prepared to vote on 5211 Filbert Street, City Affirm.
City Affirm.
Affirmed.
I guess Mr. Walker, Ms. Washington.
City Affirm.
Okay.
City affirmed.
Thank you very much. All right, the unanimous vote is City Affirm. Sir, thank you very much for your participation. Of
Thank
course,
you.
you have the right to appeal the decision of the board. Thank you.
Thank you. And Mr. Sigmund, let's talk after I'm finished with the board hearings this afternoon.
Let's move on.
Yes, I would like to speak after offline. Okay, thank you.
Thank you very much.
Okay. Ms. Wade.
That's the case 32.
32. Okay.
Hearing appeal ending 3740, 1414 South 56th Street, Jim Jetter.
Okay. Who's representing the city?
Good afternoon, members of the board. Leonard F. Reuter, City of Philadelphia.
Okay. Mr. Reuter, you have a witness today?
Inspector Michael Herbert.
Mr. Herbert, you present? Please make yourself known to the board.
He is here.
There. Okay, Mr. Herbert, if you would unmute yourself.
I don't know if he stepped away.
No, I see him. This is Michael Herbert, correct?
Yes. Oh, there he is. Okay.
Yes. Mr. Herbert, if you could remove your hat and raise your right hand.
All right.
Do you swear or affirm the testimony you give today be the truth so help you God?
I do.
All right, thank you. You can place your hand down. Okay. Mr. Jim Jetter, are you present?
Yes, I am.
Okay. The name I see on the screen is Phyllis Jetter.
That's my wife.
Okay. Well, we'll ask someone to change that so that we can be clear on who's appealing today's matter. Would you raise your right hand, sir, so that you may be sworn? Do you swear or affirm the testimony you give today be the truth so help you God?
I do.
Okay, one question for you before we begin. Whose name is on the deed to this property on 56th Street?
My name.
Is your wife's name on it or any other party?
No.
Just yours.
Yes.
Okay, thank you very much. All right, Mr. Rudder, let's proceed.
So before we present any evidence regarding the violations, I can just say this is again another a little bit unusual matter that perhaps we can resolve with just a couple questions from the of the appellant, Mr. Jetter. This involves a vending truck that was operating without proper licenses. It's my understanding that the vending truck was parked on or next to property that's owned by Mr. Jetter. I'm sorry, and is it Jetter or Jeter, sir?
It's Jeter.
Jeter, Mr. Jeter. So if I could just ask him a couple questions. Mr. Jeter, are you the owner of the property at 1414 South 56th Street?
Yes, I am.
Okay. And what is that property used for currently? Is it just a vacant lot?
No, it's a rental property. It's a home, residential home.
Okay. Do you live there?
My tenant does.
Okay. To the best of your knowledge, is the tenant associated with the truck, the food truck in question?
He is not.
Okay. And do you have any association with the operator of the food truck?
I do not.
And has the food truck been parked on the property or in front of the property?
It was in the back of the property, and this was back in, I guess, October 23. And I did send a letter in on August 29th of 23 explaining the whole situation. I don't know if you had that on hand or not.
Yes, we do. And did you yourself make complaints about the food truck?
No, I did not. I don't know how it came to the attention of L&I.
And is the truck currently operating, or is it just a truck that's parked there?
Well, I don't even think it was a truck. There were cars parked there that this person in the neighborhood was selling, and he didn't have license plates on the cars. And my tenant learned about it, and she confronted the person, and initially he refused to remove his cars from my property. She told him that she would have those cars towed if he did not remove them because she didn't want them there. And he again refused to do that, and she started having the cars towed. And at that point, again, this is back in August of 23, he removed his cars from my property. And he has
Okay.
not been putting any further cars back there.
All right. Thank you then. So at this point, then, I think I can just call Mr. Herbert and just ask a few questions of Mr. Herbert. This may be another situation not unlike, I mean, although a very different context, but not unlike the plumbing permit violation, where the current violation was not issued as a zoning violation or involving a condition of the property. It was literally a violation that was issued by the vending unit. So, Mr. Herbert, if you could just state your name for the record.
Michael Herbert.
Okay, and what is do you work for the city of Philadelphia?
Yes, I do.
What's your position with
inspection?
I'm sorry?
The Department of License and Inspection.
Okay, and what's your position there?
I'm an inspector, code enforcement inspector.
Okay, and are you familiar with the property at 1414 South 56th Street?
Yes, I am.
Okay, and what brought you to the property?
There was a food truck parked adjacent to the property. There was a service request I received in my to-do list. And unfortunately, a lot of times when these service requests are generated, they will use the address that the food truck or food cart or whatever it is that has to do with vending is adjacent to. But oftentimes, and because they don't really know that the violations for a conveyance have to be written as non-address. So wherever they're near, a lot of times we're finding that the violations are going to the property owners who have nothing to do with what's going on, the illegal vendor parked on the street.
So in this matter, would the city then withdraw the violation against Mr. Jeter and reissue a new one just with respect to the truck?
Yes, the actual owner of the truck, his name is Alexander Boaki. I spoke with him directly. He had a number of food trucks over the years that I've written violations on for not having licenses and being unattended.
Okay.
I parked on the street overnight.
Thank you. Mr. Chair, based on this information and the fact that Mr. Jeter has confirmed on the record under oath, and the inspector has also testified under oath regarding this, I believe the city will withdraw this violation against Mr. Jeter, and we will reissue a new violation against the actual operator of the food truck.
Okay, well, noted as withdrawn. Thank you very much, Mr. Jeter. Have a good afternoon. This matter is withdrawn, sir.
Thank you, sir.
Thank you.
Okay, your witnesses are also excused.
Thank you.
I believe that brings us to our final three matters. I don't know if they are to be heard as one matter or three separate matters. Cases number 52, 53, and 54.
Okay.
Case number 52, hearing appeal ending 3806 5225 Dickinson Street, Jacqueline Warren. 53.
Yes.
Case 53, hearing appeal ending 3807 1525 Dickinson Street, Jacqueline Warren. And case number 54, hearing appeal ending 3808 1525 Dickinson Street, Jacqueline Warren.
Okay,
Yes.
who's representing the city?
Good afternoon, members of the board. Jeffrey Cohen again for the city of Philadelphia.
Okay, Mr. Cohen, good afternoon. Miss Jacqueline Warren, ma'am, would you pronounce your last name, please?
Jacqueline Warren, Wearen.
Warren, good afternoon, ma'am. Would you raise your right hand so that you may be sworn? Do you swear or affirm the testimony you give today be the truth to help you God?
Yes, I do.
Okay, Mr. Cohen, do you have any witnesses today?
Yes, inspectors Martin Dean and Roberto Rivera of LR.
Okay, Mr. Dean and Mr. Rivera, would you please unmute yourself so I can swear you in? I
am on mute.
Okay. Both gentlemen, raise your right hand, please. Mr. Rivera, unmute yourself. Do you swear or affirm your testimony you give today be the truth so help you God? Mr. Dean?
I do.
Mr. Rivera?
I do.
All right, thank you very much. Place your hand down. Okay, Mr. Cohen?
Thank you. These matters will be heard at the same time. Essentially, they are separate notices, but for essentially the same course of conduct. There's two notices of violation. One was issued for unfitness of the property due to a sewage leak, and the other was issued for various fire and property maintenance code violations.
Okay.
The third is a site violation notice for lacking a required rental license. The city is going to put on Inspector Dean first to show you what he found at the beginning of the case, and then we'll have a little from Inspector Rivera at the end about about current status as he has seen at the property.
Okay, thank you.
So Inspector Dean, if you could please tell us, through the course of your duties for L&I, have you been to the property at 1525 Dickinson Street?
Yes, I did go to that property.
And I'm going to share on screen the city's exhibits packet that's been previously provided to the board and to the appellant. Scrolling now to page 3 in the packet. Did you take this photograph?
Yes, I did.
Was it on the date and time listed here?
Yes, it was.
Who is the person in the foreground of this photograph?
That is Miss Sims.
And
Markeisha Sims.
What is her relation to this property?
She presented herself as the tenant in that property.
And just for the record, is this a photograph of the basement of 1525 Dickinson Street?
Yes, it is. And if you notice the stains on the floor, that is the water stains where the sewage was coming from the back of the property.
Could you tell us about the violation, the unfitness violation pertaining to the sewage?
The home was unfit due to that sewage in the basement.
Is there a particular concern about leaking sewage in a basement?
Yes, it's definitely unhealthy, unclean, and it could also affect the neighboring property.
Be quiet, be quiet.
Okay, wait a minute, just for a moment. Ms. Warren, are you in a public place?
I'm in my house.
Okay, but I hear voices in the background. So is there someone else you can go so that you don't get interrupted? Ms. Warren?
I hear you.
You didn't respond.
I'm sorry, I muted her. That's my granddaughter. I muted her.
Okay. All right, thank you.
All right, Inspector Dean, if we can continue. Does this photograph accurately depict what you saw on August 18th of 2023 at 1525 Dickinson Street?
Yes, it does.
And just for the record, this tag here that says 1524 Dickinson Street, is that an accurate tag on this photograph?
No, it's not. Sometimes when you take the photos, it gives you the neighboring address. But it's a totally different address altogether.
But is the time and date correct?
Yes, that time and date is correct.
Thank you. Moving to the next exhibit in the packet, Inspector, what is this exhibit?
That is the notice of violation.
The notice of violation specifically for unfitness due to repair defective sewage drain?
Yes.
And that's location is in the basement?
That was in the basement.
And was this issued to the appellant Jacqueline Weirin?
Yes, it was.
And is this a record that L&I keeps in the ordinary course of its business?
Yes, it is.
And is this something that is created through the course of your duties as an inspector?
Yes, it is.
And just to clarify the violation that's on the second page here, which is page 5 in the packet, that's a property maintenance violation for repaired defective plumbing stack?
Yes.
Thank you. Just for the noting for the board that the full appeal, excluding the NOV itself, but including all other exhibits, is listed here Exhibit C3 on page 7. However, because this same appeal paper was reused for the 3 different appeals, I've only included the documentation here on pages 8 through 13, and not with the other instances of this particular appeal.
Okay, thank you.
Sorry, I'm going to scroll through the appeal documentation. I'll wait for Inspector Rivera. Inspector Dean, what is this document that I have on screen?
That is the document that appears to be from Eclipse.
This is a permit search,
Yes, it is.
the publicly available search.
Yes, it is.
Are there any permits in Eclipse for 1525 Dickinson Street?
And none that I was able to find.
And would there be a plumbing permit, or would you, let me rephrase. Would the owner need to pull a plumbing permit in order to address the sewage leak issue in the basement?
Yes, usually when they get a contractor, that would be the responsibility of the contractor to pull that cert so that they can do the repairs.
Thank you. Now moving down here to page 17 in the packet, which actually addresses, now we're addressing the violations, or the notice violations for fire and property maintenance code issues. Can you tell me who took these photographs that are in exhibit C6?
I took those photographs.
And they're also accurate photographs of what you saw on August 18th of 2023 inside the property?
Yes, they are.
So what's depicted in this photograph?
Right there, what you see is a smoke detector. It did not appear to work. As the tenant tried to push the button, you can see it literally hanging from the wall.
Well, is the lack of a working smoke detector itself a fire code violation?
Yes, it is.
And is the lack of fixation or the hanging smoke detector itself a separate violation dealing with hanging fixtures?
Yes, it is. That hole should not be there. It should be attached to the ceiling.
Meaning the electrical box that we see up here with the actual electrical wiring should not be available for someone to touch with their finger if they get up on a ladder?
Yes, exactly.
Thank you. And scrolling down to the next photograph, what's depicted in this photo?
Again, we have a smoke detector. And again, this one, when the tenant attempted to activate it, it did not appear to work.
And for a building like this with this particular tenant, are there required to be multiple smoke detectors?
We do require smoke detectors to be in the basement, first and second floor, or any floors where you might have tenants located.
Does that also apply to carbon monoxide detectors?
The carbon monoxide detector specifically should be within 75 feet of the bedrooms. So they can place those out in the hallway.
And when you were there on August 18th, were there carbon monoxide detectors in the locations that are required by law?
There was not a carbon monoxide detector.
And moving down to the next page, on page 19, what is depicted in this photograph?
Here we have a light switch that is missing its cover.
And again, is this something where you could stick your finger behind that switch and touch the wires behind it?
Yes, there is a danger of electrocution.
And so it should have a panel cover.
Yes.
Moving down to this page, page 20, this photograph, what's depicted here?
That is the light fixture in one of the bedrooms, and that specific light could not work. I'm not sure if you noticed there's a small bulb on the other side. Forgive me for the bad photo.
Well,
Yes.
if you're here to describe what's in the photograph, I think we can see the underside, or what is sort of down in the photo underneath this black connector. Is that the bulb you're speaking of?
Yes, it is.
And did that bulb work?
That bulb did not work.
And is there any bulb in the other side of this connector, which is the top end of the photograph?
No, there is not.
Scrolling down to the next photograph, what's depicted here on page 21?
Right here, you have a photo of the floors leading up to the second floor level. And if you notice, much of the wood is starting to come up and the floor is in severe disrepair.
Well, when you say the wood is starting to come up, does that mean it's starting to warp out of place?
Yes.
And what are we seeing here with these with this floor covering?
The tile itself is very old and it's starting to peel.
And is the peeling tile itself a violation of the Philadelphia Property Maintenance Code?
It definitely is. It can cause someone to trip or fall.
And scrolling down, oh, I'm sorry, is this over
Yes,
here down at
that's
the bottom of the photograph? That's
yes.
Is that a separate violation of the Property Maintenance Code?
That's part of the floor, asking
Oh,
them
okay.
to repair that floor where the wood is starting to come up.
And going to the photograph on page 22, what is depicted here?
Now that is the ceiling in one of the bedrooms where rain is pouring into the ceiling and causing that damage that you see.
So looking at this here, it looks like there's a white covering to the ceiling, and in this corner, that covering is broken away.
Yes, part of the ceiling appears to have fallen.
And this is caused by rainwater penetrating into the property.
Yes.
And is a leak into the property a separate violation of the Property Maintenance Code?
Yes, it is.
Scrolling down here to page 23, what is depicted on this page?
Once again, you have another bedroom, and that area, you have the same issue happening. You have rainwater damaging the ceiling, and as you can see, it's also damaging the wall.
So if we look at this sort of brown staining along this crack here, is the brown staining caused by water penetrating into the building?
I believe so.
And is that similar along this wall headed down sort of in little lines? Is that water dribbling down the wall?
Once again, I believe so.
And are those violations of the Property Maintenance Code?
Yes, they are.
Just briefly, what is depicted in page 24 in the packet?
Once again, you see more wall damage and ceiling damage due to the water, the rainwater that's coming into that room.
And is that the same on page 25?
The exact same thing.
Now on page 26 in the packet, what, if anything, is depicted in this photograph?
Now that specific door, you're not really going to be able to see this in the photo itself, but when that door was open, it was hanging off the hinge.
Well, if we look at the top of the door in the photograph, it looks like there's a little bit of a gap on the right side, but then on the left side, it fits snug in the frame.
Yes, she kept it closed so that the door would not fall.
Does that mean the door is sort of improperly sitting in the frame?
I wouldn't say it's improperly sitting in the frame, but the door hinge does not have it secured to that frame.
And is that a violation of the Property Maintenance Code?
Yes, it is.
Is this an interior or an exterior door?
That is an interior door. I believe that one is leading to a bathroom.
Okay. Are there other exterior doors that were not properly fitted in their frames?
Now, I can't remember that right off the top of my head.
Okay. Well, let me move down now to page 27, which is Exhibit C7 in the packet. Is this the violation notice pertaining to those photos we just saw?
Yes, it is.
Was this also issued to Ms. Weir?
Yes, it was.
And is this a document L&I keeps in the ordinary course of its business?
Yes, it is.
And is this something that the information that goes into this is entered by you through the course of your duties?
Yes.
So just to summarize for the board, we do see the carbon monoxide detector and smoke detector violations. Moving on to page 28, some of the same violations that we just saw, but here, this one here for weatherproofing doors. Were there photos in the packet of doors, exterior front and rear doors that were not properly weatherproofed?
I can't recall, but if there was, you should have seen them.
But did you see when you were there, exterior front and rear doors that are not properly weatherproof that may allow, may have gaps that allow entry of like cold or warm air?
Yes, both front and rear doors was definitely appeared to have some of the interior stuffing coming out and allowing air to come inside the property.
And would that also make it uncomfortable if the weather is either uncomfortably hot or cold on the inside?
Yes, it would.
And we have here another violation for weatherproof or failure to weatherproof windows. Basement, first, second, and third floors, living, dining room, kitchen, bathroom, bedrooms, and hallways. Were these also issues that you saw on August 18th?
Yes, they were.
Would that, similar to the doors that are not weatherproofed, also have an effect on the comfortableness or the interior of the property during extreme cold or hot weather events?
Yes, it would.
And moving on, we've already seen photographs about defective switches, outlets, leaks. Did you see in the kitchen, did you test the oven while you were there?
Yes, the tenant attempted to turn the oven on and it did not come on, or did not appear to come on.
And did you also look in the cabinets in the kitchen while you were there?
Yes, I did. And some of the cabinet doors had broken off.
And was that also, were there other cabinets in the second and third floor bedrooms with similar issues?
There were different types of cabinets in those rooms, but yes.
And while you were there going up and down the stairs, did you note any issues with the handrails?
Yes, the handrail was detached from the wall itself.
And lastly, while you were there, did you see anything or observe anything at issue in the third floor bathroom with the plumbing?
The third floor bathroom had a leak and the fixture was pulled away from the wall.
Was that in the same area as the roof leaks or ceiling leaks that we saw in your photos?
Well, the roof leaks were in different areas they were in all the bedrooms basically. So that expanded most of the roof itself. So yes, it would have been in a different area.
Thank you.
You're welcome.
And again, for the board, this is the same appeal form, but again, the exhibits are up further in the city's packet. I haven't reproduced them here.
Okay.
And for the board's sake, this is the section A105 on owner responsibility. Just reiterating under the Philadelphia Code that the owner is responsible for testing, maintenance, and repair of their property. And a lease with another individual, like an occupant, does not relieve the owner of that responsibility, though it may transfer some responsibility to the tenant that the tenant would also have. And this is also in the Property Maintenance Code. Under PM 301.2, the owner of the premises shall maintain the structures and exterior in compliance with the code's requirements, or the Property Maintenance Code's requirements. And also on page 34, under the Fire Code, the correction and abatement of violations of the fire code shall be the responsibility of the owner. If an occupant creates a condition, the occupant can also be held responsible, but the owner is in every case responsible. And Inspector, if I can point you to 35, page 35 in the packet, this is exhibit C12, which the city has redacted and added highlighting, which are not in the original. Did you take this photograph of this document?
Yes, I did.
Who showed you this document?
The tenant, Miss Sims.
What did, if anything, or actually, let me rephrase it. What do you take this document to mean?
The tenant herself informed me this was the document and the agreement given to her by Mrs. Warren, allowing her to rent that property.
And just for the sake of the board, or actually, let me ask this through you, Inspector. At the top of the document, does it say the City of Philadelphia Department of Revenue Water?
Yes.
So does this document actually pertain to rental, or does it pertain to water utilities?
I'm not certain, because the information that was given to me from the tenant herself informed me that gave her the responsibility over the water, but it was also part of a documentation that allowed her to rent that property.
Okay. Well, in the middle here, does it say, I, Jacqueline Weirin, authorized my sister-in-law, Markeisha Sims, to reside in the property at 1525 Dickinson Street?
Yes, it does.
And then the next paragraph, Markeisha Sims is also responsible for water usage at this property.
Yes.
And I'll point out to the board, this is signed in the presence of notary Linda and Saunders. The process for getting a notarized signature being more onerous than just having a person sign themselves, because it requires going to the notary, presenting identification, which we can see copied here, and then having the notary log it in their logbook.
Mr. Cohen, that New York State document, is that the certification of the notary?
Well, actually, let me ask this of the inspector. What is this portion here, this New York State identification card?
It was explained to me that was the identification of the owner of the property, who was identified to me as Ms. Warren.
Thank you very much. And let me scroll down to page 36. What is this notice that is on the screen?
That is a notice of violation.
Specifically for lack of a required rental license?
Yes, for not having a rental license.
And just to separate this, or to treat it distinctly from the two previous notices of violation, is this a site violation notice for a specific date?
That is specifically for not having the rental license.
Yeah, so sorry, my question being, is this an ongoing NOV, or is this a one-day site violation notice?
No, that was a one-time violation.
Thank you.
You're welcome.
Oh, what is the date of that NOV, that site violation? 8/21. Okay.
And again, I have the board appeal, but again, the exhibits are up further in the packet. I haven't duplicated them yet again here.
Okay.
Inspector, is there in fact a rental license or any property license of any type for this property?
I have not seen or been able to find a rental license for that property in the system.
And here on page 39, is this an Eclipse public search for business licenses?
Yes, it is.
And does it say, well, what does it say about the licenses for 1525 Dickinson Street?
At the top in red, it says no information was found matching your selection criteria. Please try again.
Thank you very much, Inspector.
You're welcome.
I don't have any further questions for this inspector at this time. And if Ms. Weirin wishes to ask him any questions, I can use the exhibits on the screen or stop sharing my screen, whichever she prefers.
Okay. Ms. Warren, do you have any cross-examination of the inspector based on his testimony?
Yes, I would like to speak.
Now, Ms. Warren, this is
Excuse
your
me?
opportunity to ask him a question based on his testimony. You can give us testimony of your own once the city is finished putting its case on, okay? So I just want to make that distinction for you. Do you have any questions for the inspector? If not, that's
No.
okay. Okay.
No, I don't.
Okay. All right, Ms. Cohen, continue on, please.
Thank you. Before I bring in Inspector Rivera, I actually want to scroll down in the packet to page 40. There's actually an action in the local court of common pleas filed by Ms. Weirin against Markeisha Sims, the tenant, for ejectment. And what I'd like to show the board, I'm not going to get into the pleadings. What I'd like to show the board is one particular exhibit in the defendant's answer, which is this, which again is signed by Jacqueline Weirin in the presence of a notary. which you can see the notary stamp here, and you can also see it's blurrier, but you can see a state ID was photocopied with this. The inspector previously mentioned that there was a document for the Philadelphia Water Department or Water Revenue indicating that Ms. Markeisha Sims was responsible for paying the water. This document that Ms. Sims included in her answer, which again is signed by Jacqueline Weirin in the presence of a notary and is therefore an admission of Jacqueline Weirin, dated March 30th of 2021. It is called a lease agreement. It says, I, Jacqueline Weirin, is giving my sister-in-law, Markeisha Sims, permission to occupy property at 1525 Dickinson Street, Philadelphia, PA 19146 on a rent-to-own basis. So if the board is looking for a particular lease, which is not strictly a requirement of the rental license requirement, but is one of the ways in which a rental license is required for a property, this document on page 54 of the city's packet is that lease.
Okay.
And with that, the city would call Inspector Roberto Rivera.
Thank you.
Inspector Rivera, are you there and unmuted?
Yes, I'm here.
Sorry, I didn't see you pop up. So, Inspector Rivera, have you also inspected the property at 1525 Dickinson Street?
I have, yes.
And specifically jumping to page 14 in the packet, what is this photograph that I have on screen?
That is a photograph of the property, 1525 Dickinson Street.
Who took this photograph?
I did.
And is this an accurate representation as of July 17th of 2024 of the exterior of the property?
Yes.
Were you able to gain access to the interior to confirm the ongoing nature of the violations?
Unfortunately, no.
Have you received any emails or phone calls from the owner or from Ms. Sims, the occupant, about this property?
Miss Sims, yes, the occupant.
Well, we won't get into anything that another person told you, but have you been given any access by either the occupant or Ms. Weirin to enter the property to inspect?
No.
Did you review whether there are any licenses or permits issued for this property?
Yes.
Were there any licenses or permits issued?
No.
And specifically, when you were there, scrolling down to page 15, did you make any attempt to contact the person or any person who might have been inside?
Yes. I left my card at the door. Also, if you see there is a Ring camera. I also left a message on the Ring camera.
And have you received any response to date?
Yes, by Ms. Sims.
Or I should ask, instead of asking what someone else has told you, have you been able to gain access to the interior since that time?
No.
Thank you very much. The last thing that I would ask is, are violations considered complied if an inspector is not able to physically see that they are corrected?
No.
Thank you very much, Inspector.
Thank you.
Thank you. Ms. Warren, do you have any questions of Inspector Rivera? You muted, ma'am.
No, I don't. I don't have any questions for him.
Okay, thank you. Mr. Cohen, do you have any additional witnesses?
No, I would like to thank Inspectors Dean and Rivera and ask that they be excused if they're finished with their testimony.
Well, not yet, because there may be some follow-up questions from the board. So I asked them if they can to hang around for a moment until we get through the bulk of this. Is there any additional witnesses, Mr. Cohen?
No, that is all for the city's presentation other than potentially rebuttal. Thank you.
Okay, thank you. Do you want to move for your documents to be placed in the record?
I was going to move at the end, but yes, I can move the documents presented in the city's exhibits packet into the record.
Okay, so move. All right, thank you. Ms. Mary, what would
Yes.
you like to tell us regarding matters at 1525 Dickinson Street?
Okay, first of all, Markeisha Sims is not a tenant. Markeisha Sims sent me a letter and asked me about the house. I told her the house was not in any condition to live in and I needed to get it fixed up. I was just getting out the hospital. She said, oh, well, I can help you manage it. Because she said she was going to move to, excuse me, she was moving to Jersey to live with her aunt. And I said, okay. So she got in the house. She changed the lock. She sent me a key. I said, well, as soon as I get better, I'm going to come. She said, well, no, let me get it fixed up. So I start cash apping her money to fix the house up before all of this license and inspection. She called them on me. I have photos of where this girl is terrorizing the neighborhood, although it may have nothing to do with this. When I go to court, I'm going to present all of that. She busted a man in the head.
I'm going to object at this point.
Miss Waring,
Okay.
I'd like you to keep your testimony
Okay.
to this matter, please.
Okay. Markeisha Sims, I would talk to her on the phone. Like I said, she was with my brother. I had never met her, but we talked on the phone. She came up here as I was getting out the hospital. I didn't even know who she was. Then I found out who she was. So she said, well, I'm going to need your ID. She wrote up that letter. She said, I'm going to need your ID. So if somebody comes, they'll know that I'm legit because I have your ID. And I thought that was legit. I said, okay. With the $5,000, she didn't fix anything up.
What $5,000?
Oh, it's on the Cash App. They scrolled past
Now,
it.
I'm asking you, ma'am, you haven't told us that any,
Oh,
what
I'm
was
sorry.
$5,000?
I sent her $5,000 on Cash App.
Okay.
I was sending her like $600, $500, $400, because she said she was going to manage the house and she was going to have it fixed up. I even sent my granddaughter there to put in a water tank. She cussed my granddaughter out and wouldn't let her in. The police has been to my house. I had to call RG&E to try to get them in there to fix that problem. She wouldn't let them in then. They had to call the police, and I was on the phone with them then. So
Okay.
all of this came after that. She spent my money, and she didn't do anything.
Okay.
And like I said, I know the house is in bad condition. I didn't know it was that bad, but it is in bad condition. But she won't let nobody in there to fix anything up. And it's on police record. The police done been there. The sheriff department done been there. They sent me letters where they showed me where they put it in the ring camera. All that showing.
Okay. Thank you. Mr. Cohen, any cross-examination?
Yes, if I could please share my screen. Good afternoon, Ms. Weirin. Just let me know, can you see what I have on screen?
I see that.
Excellent. So I'm actually going to scroll up to page 53 in the packet. Is this, on page 53, is this a statement of the real estate taxes for 1525 Dickinson?
Yes, it is.
And the certified owner is you, Jacqueline Weirin?
Yes.
But you see this postal money order here for $600. That's Markeisha Sims, correct?
Correct. If you, okay.
Well, hold on. I'm scrolling to the next page at the moment, page 52. This is a water and sewer and stormwater bill also for 1525 Dickinson.
Mm-hmm.
And this is also in the name of Markeisha Sims, correct?
Yes.
And here on page 51 in the packet, is this a Philadelphia Gas Works bill?
Yes.
And that's also in the name of Markeisha Sims
Sims.
for 1525 Dickinson?
Yes.
I'm going to stop sharing my screen. So Markeisha Sims is paying for utilities at this property, correct?
Yes, she is. I had them turned off. They let her turn them back on. They called me from the water company. It was a big bill from the other people that stayed there, family members. And I told her, I said, well, the water's going to get cut off. She said, well, with that paper, I can get it cut on so that the people can do the work in the house. They're going to need water to do the work in the house. She said they're going to need electric and gas to do the work in the house. So she's agreed to get it cut on in her name.
Okay.
I have no further questions for Ms. Weirin.
Okay. Anyone else have any questions of the appellant. Alrighty. Miss Warren, you
Yeah.
you currently residing in Rochester, New York?
Yes, sir.
Okay. Have you ever lived in this address on Dickinson Street, Philadelphia?
I was born and raised in Philadelphia. My
Okay.
parents left me that house. They deceased. I refused to
Okay.
let her keep it.
Okay. So the house was given. You became owner through
My
the
deceased
estate.
parents.
Okay.
Yes.
All right. Now, is it your position that the property should be vacant and that you didn't authorize Ms. Sims to have access to the property?
When she told me the condition of the house, I sent her letters and I asked her to move. She blocked me. I couldn't get in contact with her no more. Anything she sends me, and I have that proof too, she put 1401 City Hall as city address.
Okay.
Everything that she sends me.
Okay. So the letter, the agreements that we saw earlier, where both of you signed them, authorizing her access to the property, you're saying those are fraudulent?
The way that we talked about it, she wrote it. She
No,
wrote
I'm
it all.
asking, but I'm asking you a question. Are they legitimate? Did you actually sign those documents?
Yes, I did sign that document. Yes,
Okay.
I did. I'm not gonna lie about that. I did.
Okay. Okay. All right. Now,
Yeah, I have a question when you're done. I'm sorry.
yes, just one thing. Do you currently have a case in common pleas court regarding to get her evicted?
Yes, I do, because she's squatting now. She
Okay,
won't let
now,
nobody in.
when is that scheduled to be heard?
It's in September. I'm waiting for them to send me the date.
Okay, thank you.
And
You
I
have
have to come there.
Yeah, you have legal counsel representing you?
Oh, I will have some.
Okay. All right.
Hopefully.
Thank you. Mr. Tennant?
Yeah, Ms. Warren, how long has the property been unoccupied before Ms. Sims inquired about it? How long were you away from the property and it unoccupied?
From my understanding, when my other granddaughter left, neighborhood people went in there and took over. And then somebody got them out, and then that's when she went in and sent me pictures of how everything was. And that's when I started sending her money.
After your granddaughter moved out, did you ever come to Philadelphia to see your property?
No, I didn't. Because my
When's the last time you were at you?
I'm sorry.
Ms. Warren, you have to wait until he finishes his courses before you respond.
When was the last time you came to your property in Philadelphia?
I haven't been to Philadelphia since 2012.
Thank you.
All right. Thank you very much. All righty. Any final argument, Mr. Cohen?
Yes, thank you. I want to share again on my screen the rent-to-own agreement between Markeisha Sims and Jacqueline Weirin that Jacqueline Weirin admitted she signed in the presence of a notary. Now, all of the evidence in this case indicates that there is a conflict between the renter and the owner.
He's not renting.
Ms. Warren, he's no interruptions,
I
please.
apologize.
Okay. All right, Mr. Cohen.
So at this time, right now in 2024, it's more convenient for Jacqueline Weirin to make claims like she's not a tenant, she has no lawful right to be in this property. But looking at this document that was signed, again, in the presence of a notary, a neutral third party required by law to check everyone's ID when something is signed, this indicates that there was an agreement, that they did have an agreement for rent to own. And the agreement goes further and says that Sims will be responsible for all utilities and past bills, including water and taxes. And you saw Ms. Sims's documentation from her answer that Ms. Weirin says, you know, this is her bill. This is her gas bill. This is her water bill.
Yeah.
This is the tax bill that Markeisha Sims has been paying, not Jacqueline Weirin. So what we have here is an unfit property. There's been no real contention or disagreement between Ms. Weirin and the city that there are certain violations of this property that need to be addressed. Really, the conflict here is that there is a tenant who's living in an unfit property who wants the owner to fix it up, and the legal responsibility is on the owner to fix it up, and the owner doesn't want to because that would be expensive.
Ms. Warren, please, excuse me, Mr. Cohen. Ms. Warren, would you please mute yourself if you can't control your voice? Because we can hear all those comments you're making. So please mute yourself, please. Ms. Warren, thank you.
So instead, we have an owner who has now taken her tenant to court to try to evict her from the property, which the tenant in March of 2021 thought that she was renting to own. The tenant wanted to become the owner of the property and assume the responsibility. But now the owner is fighting tooth and nail to keep the property and to not have to pay for the repairs to a property that is designated unfit, that is really no one should be living in, or it should be fixed up immediately, because Ms. Sims is owed a duty under the law of living in a property that is fit for human occupancy, that doesn't have electrocution hazards or fire hazards or a sewage leak in the basement. So the question before this board is, do the violations exist? Are they the responsibility of Jacqueline Weirin as the owner of the property? I think the answer to both is yes, the violations exist. We've shown the photos. With respect to the rental license violation, we've even shown the lease. Is it the responsibility of the owner? That is what the code says. In fact, we have the provisions of the code here requiring an owner to maintain the structure in compliance with the property maintenance code, requiring an owner to be responsible for the testing and maintenance of all systems. And we also have here under 93902, the requirement of any dwelling let for occupancy must have a rental license. And in this case, we not only have let for occupancy, we actually have the rent to own agreement itself. So I believe that the city has shown sufficient evidence that this should be city affirmed. And I would also remind the board the weight and the burden of production here is actually on the appellant. So it's on the appellant to show that in fact the city is wrong on all of these counts. So the city respectfully requests the city affirmed on all three cases.
Thank you. Ms. Weirin, any final comments before we vote?
Yes. Okay. Now they seen that damaged water in the sewer. Why didn't license and inspection shut it down then? I'm not saying I don't want to fix up my property. I do want to fix up my property. When I sent people to do work on the property before it got this bad, she wouldn't let anyone in. So how can I get work done when she cussing people out? It's on police record. My parents left that to me. Why would I let it go to the dogs like that? And I was sending her money, and that $600 taxes that she paid, if you look on the cash app receipt, that's where she got the money from to pay it. She never paid no rent. She never paid anything. There was never a contract. She photocopied a lot of stuff. All the stuff she sent me that said it came from the city, I'm taking it all to court when I go to court in September.
Okay. Thank you very much. We will now poll the board. We will vote on each one of these matters separately. I'm getting some feedback. I'm not sure where that's coming from.
I know I owe fines.
So, Ms. Warner, if you would mute yourself, I think you're getting some feedback from your space. We will poll the board on HA-2023-003806-1525 Dickinson Street. Jacqueline Weirin, city firm.
City affirmed.
Affirmed.
City affirmed. Bill sustained.
Thank you. The majority vote is city affirmed. Ms. Warren, you lost your appeal. The next matter is HA-2023-003807-1525 Dickinson Street, Jacqueline Warren, city affirmed.
City affirmed.
Affirmed.
City affirmed. City affirmed.
Thank you. Majority, I'm sorry, unanimous, city affirmed. The
Excuse me,
last,
Mr. Chair, did Mr. Washington vote?
Mr. Washington, yes,
Yeah.
you're right. Mr.
Okay.
Washington, we need your vote on the record.
Well, you should be there. City affirmed.
All right, thank you very much. Alrighty, let's go to the final matter, number 54, HA-2023-003808-1525 Dickinson Street, Jacqueline Warren, city affirmed.
City affirmed.
Ms. Penn,
City affirmed.
City affirmed.
Appeal is sustained.
Yes. Okay. Majority vote, city affirm. In this instance, Ms. Warren, your 3 appeals have been lost. You may appeal our decision. If you need information as to how to appeal our decision, check with the administrator's office and they will give you whatever necessary information you need. Thank you very much, ma'am. Have a good afternoon. Okay.
Thank you, members of the board. May Inspectors Rivera and Dean be excused.
Yes, the inspectors are excused. Thank you so
Thank you.
much. Okay,
Thank you.
Mr. Wade, do we have any additional matters to deal with today?
No, we do not.
Okay, everyone, thank you so much for your participation and your patience. Today's been a long day. That concludes today's hearings. Have a good evening.
Have a good evening, everyone.
Yep.
Good evening, everyone.